Thank you. I welcome members and also viewers who may be watching our proceedings on Oireachtas TV to the public session of the Joint Oireachtas Committee on Children and Youth Affairs. The purpose of today's meeting is to discuss non-publication of the operational review report on the Oireachtas Children's Detention Campus. In the first session, the committee will hear from the authors of the report, Professors Barry Goldson and Nick Harwick. In the second session, the committee will hear from the chairperson of the Board of Management of Oireachtas Children's Detention Campus, Professor Ursula Kilkenny. I wish to advise members that while there have been reports in the media in connection with the operational review, it's important to note that the committee cannot discuss individual cases and should avoid naming individuals, whether these names are in the public domain or not, and should not discuss anything that is likely to be the subject of court proceedings. Members are reminded that there are ongoing legal cases and that they should avoid saying anything that could have an impact on these cases or be seen to interfere with them in any way. Members are advised that the contents of the operational review report cannot be discussed and that they should be mindful of the legal issues surrounding the report. I welcome to the meeting here Professor Barry Goldson, who is a PhD, who is with the Charles Booth Chair of the Social Science in the Department of Sociology, Social Policy and Criminology in the School of Law and Social Justice at the University of Liverpool, and Professor Nick Harwick at the School of Law at the Royal Holloway, University of London. You're very welcome, gentlemen.
Thank you.
I thank the professors for appearing before us this morning. But before we commence in accordance with the procedure, I am required to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of the evidence before this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to qualified privilege in respect of your evidence. You are directed that only evidence connection with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any persons or entity by name in such a way as to make him, her or it identifiable. Members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against a person outside the House or an official either by name in such a way as to make him, her or it identifiable. May I remind all members and indeed guests and witnesses to please switch off your mobile phones or switch them to flight mode, as they will interfere with the sound system and make it difficult for parliamentary reporters to report on the meeting. Mobile phones also adversely affect television coverage and web streaming. I wish to advise you that your submission or opening statements that you make to the committee will be published on the website of this committee after the meeting. I understand that witnesses will make a short presentation today, followed by questions from the members of the committee. And I now call on Professors Goldson and Harwick to make their opening statement, please.
Thank you, Chair. I'm going to make a short oral statement on behalf of us both.
Thank you.
And thanks for the invitation. We very much welcome the opportunity to address the committee. Members of the committee will appreciate, of course, that it's impractical for us to attempt to cover every aspect of the events that have unfolded over the previous 2 years, and instead we'll make a relatively short oral statement that aims to capture the key issues, and we've provided the committee with a more detailed written statement that we've entitled Synopsis of the Operational Review of Oireachtas. In September 2016, we were appointed to undertake an operational review of Oireachtas in recognition of our international expertise in the fields of youth justice and penal detention. The operational review took place against the backdrop, as the committee will appreciate, of substantial change and during a period of acute instability at Oireachtas. The terms of reference for the operational review are attached as an appendix to our written statement. The core aims of the operational review were threefold. First, to evaluate practice and policy in relation to international standards and best practice principles. Second, to identify obstacles or barriers to achieving greater implementation of international standards and best practice. And third, to make recommendations to ensure greater and more successful implementation of these standards. On October 10, 2016, we sent a detailed memorandum to the Chair of the Oireachtas Board of Management, setting out our understanding of the operational review, indicating the design methodology that we intended to adopt in order to undertake it, and identifying the key data information that we anticipated we would examine. The design and methods of the operational review are elaborated at paragraphs 8 to 12 of a written statement, and the full memorandum is provided as an appendix to the same statement. In the time available for us to undertake the review, the design and methods were rigorous and robust. Throughout the entire process of designing, undertaking and reporting the operational review, we consulted consistently and closely with the Chair of the Oireachtas Board of Management and with the Director, and illustrative detail is set out at paragraphs 15 to 32 of our written submission to this committee. At no time prior to the submission of our report did either the Chair of the Board of Management or the Director raise any concerns with us about any aspect of the review process. On February 24, 2017, we submitted to the Chair of the Oireachtas Board of Management what we consider to be the final version of our report, together with 9 annexes and a summary report. We also provided in the very same correspondence a document tabulating in forensic detail how we had responded to the written feedback on earlier drafts of the report offered by the Chair and the Board of Management, and further documents offering similarly detailed explanation as to how we had responded to the Director's written feedback. The body of the report comprises 285 substantive paragraphs, extending over 67 pages, and it includes 95 recommendations. The body of the report does not identify named individuals other than the Chair of the Board of Management and the Director. We do not believe that there are any other individuals who can be personally identified in the report whose role is subject to direct or implied criticism. On March 13, 2017, we received a written communication from the Chair of the Board of Management in which he stated, and I'm quoting, "I form the view that legal opinion may be necessary prior to publication." On March 17, 2017, we submitted our report to the Minister for Children and Youth Affairs, as we were obliged to do so in accordance with our terms of reference. On May 29, 2017, we were informed by the Chair of the Board of Management that the Board had decided not to publish our report in light of unspecified legal opinion. The Chair confirmed that the intention instead was to publish the report's recommendations as a stand-alone document. On June 11, 2017, we wrote to the Chair of the Board of Management expressing our concern and disappointment regarding the decision not to publish, pointing out that this was contrary to the explicit written undertaking to publish and disseminate the report that we had been working with from the outset, recalling the detailed processes of consultation and accuracy checking that we had engaged throughout the entire process, restating our belief that the publication of the report would enable progress at Oireachtas and serve the public interest, objecting to the publication of our recommendations abstracted from the underpinning context that is presented in the body of the report, and pointing out that to do so would be misleading, and finally stating that we would be willing to consider redactions to the report in the light of legal advice, but we would first prefer to see the advice that might be deemed to make such redactions necessary. Notwithstanding this, the recommendations were published, and as the committee will be aware, the report is yet to be published. On March 19, 2018, a year after we first submitted our report to the Minister, we wrote to the Minister asking to be informed of progress being made towards the publication of the report. We were aware that the Minister had appeared before this very committee on January 24, 2018, when she reported that she was, and I'm quoting, that she intended to seek additional advice to ensure that due process had been completed. The Minister assured the committee that, and again I'm quoting, "When that happens, I will ask for the report to be published." On July 12, 2018, we received a letter from the Minister that included the statement, and I quote, "I consider that it would be misleading to publish the report now, having regard to the progress that has been achieved in the interim, and I have sought assurance from the Board that it is satisfied that fair procedures were applied. The Board has not been in a position to provide such assurances to me to date, and in the circumstances, I do not propose to publish the full report." In the period then between the time that we first submitted our report to the Minister's appearance before this committee on December the 18th of last year, 4 quite different rationales for non-publication have been mooted, and it's our submission to the committee that each is flawed. First, there's been reference to legal opinion and risk. The precise nature of such risk has never been made clear to us, however, and we have never had sight of the legal opinion. At the point when we submitted our report, our own reading was such that 4 of the 285 substantive paragraphs might need to be redacted in view of legal cases that were ongoing at that particular moment in time. In fact, we suggested redacting the 4 paragraphs in correspondence with the Chair of the Oireachtas Board of Management as early as February 25, 2017. The second reason for non-publication refers to due process and fair procedures. At various points in time, the Minister has referred to concerns regarding due process and fairness, most recently during her appearance before this committee on December 18, 2018. Taking account of the fastidious attention that we applied to processes of consultation and factual accuracy in undertaking the operational review, and indeed in preparing the report, we find it difficult to understand the basis of such concern. Furthermore, we have not been provided with any specific instances or examples where we have allegedly compromised due process or fair procedures. Third, the passage of time and the progress that has been made at Oireachtas since we undertook the operational review. It goes almost without saying that we welcome the news that progress has been made at Oireachtas, and we note the Minister's submission to this committee on December 18 of last year, in which she reported that the recommendations that we made following the operational review have been at the very kernel of such progress. Nonetheless, we strongly believe that our report should be published, whether or not the situation at Oireachtas has improved. We do not believe the right lessons will be learnt by the many individuals and organisations who are involved in the campus unless there is a full understanding of what's happened in the past. Moreover, we note that alongside the positive signifiers of progress contained within the HICWA report published in October 2018, following its unannounced inspection in March 2018, the same report provides that child protection requires some action, and the care of children, planning for children, premises safety, security and staffing and management requires priority action, and I'm quoting, priority action to mitigate the non-compliance and ensure the safety, health and welfare of the children using the service. Such observations resonate very strongly with the serious concerns that we raise in our report of the operational review. And fourth and finally, straying from the remit. In appearing before this committee on December 18, 2018, the Minister claimed that our report strays from or overextends the specified remit of the operational review. She referred to the fact that we make recommendations that pertain to national policy and, as such, are beyond the immediate powers and responsibilities of the Oireachtas Board of Management. But it would have simply been impossible to undertake a robust operational review without situating Oireachtas within the wider context of national youth justice legislation and policy. Moreover, from the very outset, we made it absolutely clear to the Chair of the Board of Management, and indeed to the Director, that we would be considering the wider national policy context as part of the operational review. This is explicitly specified in the detailed memorandum that we sent to the Chair of the Board of Management on October 10, 2016, that we have attached as an appendix to our more detailed written submission to the committee. At no time was it ever suggested that taking account of national policy issues lay outside the terms of reference. We strongly believe, therefore, that each of the 4 rationales for non-publication are seriously flawed, and that our report of the operational review of Oireachtas should be published for at least 4 principal reasons. First, to honour the terms of the contract that were issued to us before we undertook the review. Second, to provide transparency and accountability. Third, to serve the public interest and the common good. And fourth, to enable learning. To be absolutely clear, our unwavering objective has always conformed to the conception of the operational review as a supportive developmental process framed within the context of international standards and principles of best practice. But we can only reiterate our concern to the committee that the right lessons will not be learned by the many individuals and organisations who are involved with Oireachtas unless there is a full understanding of what's happened in the past. We believe that such understanding can only be realised by publishing our report. Article 9 of the terms of contract that we were issued at the outset of the operational review provide that, quote, all disputes between the board and the consultants as regards to the application of this contract will be submitted to arbitration if a mutual agreement cannot be reached between the parties. If the decision not to publish our report continues to stand, we appear to have reached the point where mutual agreement cannot be reached. On August 5, 2018, we wrote both to the Chair of the Oireachtas Board of Management and to the Minister for Children and Youth Affairs, in which we expressed our view to invoke Article 9 of the contract and move to arbitration. On October 12, 2018, we received a reply from the Chair of the Oireachtas Board of Management declining that request. To date, the Minister has not responded to the same request. We have not had any further communications either to or from the Chair of the Oireachtas Board of Management or from the Minister or to or from the Minister for Children and Youth Affairs. But we remain of the view that the report should be published and, if necessary, we also remain open to the prospect of arbitration as a means of resolving a dispute. This is not of our making and as a mechanism for ensuring that the terms of the contract are honoured, the imperatives of transparency and accountability are upheld, the public interest is satisfied, and the lessons that might derive from the operational review are put to best effect. Thank you, Chair.
Thank you very much, Professor Goldson and Harwick, for your opening statement. Just a couple of quick questions in advance of Deputy Rabbitte making her contribution. Just for context, is it your belief or understanding from the terms of reference in the contract that you have with Oireachtas that the report, as a contractual term, that this report be published? Is that your understanding?
It is absolutely our understanding.
Okay. In relation, can I clarify? Have you been paid for your work?
Yes.
Have you been paid in full for your work?
Yes,
you have.
And there is a provision in the contract where if Oireachtas or either party, if Oireachtas felt we hadn't fulfilled our obligations, they could have not paid us. So at no point has it been said to us that we have not fulfilled our contractual obligations.
Thank you, Professor Harwick. That was exactly the answer I was looking for to the question I hadn't yet asked, but thank you. Okay, in terms of you've made your position clear in relation to your straying into matters of policy and your interpretation of the standing orders, or the terms of reference that were provided to you. Do you have an understanding of the difficulty that presents in terms of what the Minister said to us in December with regard to straying from the terms?
I personally am quite surprised by that because, one is we did make it clear what the issues we were going to look at were. And all the information that we used, we obtained through Oireachtas itself. So they couldn't have been confused by what we were looking at. And if we should not have looked at some of these wider policy issues, then it's surprising to me that the recommendations that address those wider policy issues have been published. If you can publish the recommendations, why can't you publish the material that supports those recommendations? And I would also say I had personally, at her request, had a telephone conversation with the Minister on the 21st of December 2016, which was arranged because she wanted a kind of heads up on what the review had found before it was published. And at that point, she specifically asked me what our views were on some of the national policy issues we addressed in the report. So at no time did we get any kind of indication that there was concern about us addressing those issues. Of course, we accept some of those weren't things that Oireachtas itself could deal with, but they were very relevant to the difficulties that Oireachtas was experiencing at that time.
So it would be your view then that to cite the report straying into matters of public policy is not relevant to the context of which the report was based and actually adds to the thrust of the report.
You couldn't understand, I think, what was happening in Oireachtas at that point without understanding the wider policy context. And if our recommendations, all of them, can be published, I don't understand why the information that supports those recommendations can't be published at all.
Yeah, I mean, the committee has made that position very clear from the get-go. In fact, we had a lengthy discussion about it already, so I do appreciate you adding more context to your opening statement. Deputy Rabbitte and then Deputy Mitchell. I'll offer to Senator...
I'm going to actually give way to Deputy Mitchell.
Deputy Mitchell. I'll offer to Senator Warfield first and then Deputy Daly, just in context of membership of the committee. Thank you.
First of all, I want to thank Professor Goldson and Hardwick for coming in here today and for the very detailed submission that you gave us. Like, that was where I was going to be asking you questions, but a lot of them were answered in your submission. First of all, I think the failure of Oireachtas to publish this review is something that I've made my displeasure known as. I think it's important that we have this review. We need to know what was going on in Oireachtas and lessons to be learned from it. I just have a few questions in around the procedure with yourself. So if I could just ask you first off, what sort of working relationship did you have with the board during the review process?
Well, our relationship, we didn't have a relationship with the board as such. Our relationship was with the chair and with the director, and we met lots of staff. I felt we had a cordial relationship. It was conducted on very friendly terms. If you rereading the correspondence and memorandum, it was all conducted in a very friendly way. And when we had, after the report, we realised they were not happy with some of what it said. We had two very lengthy meetings with them to discuss the report. And on each occasion, I was looking at the emails we sent each other. We said, oh, good, we've sorted that out then, that we've resolved it. And we were, I would say genuinely, we're really saddened that it's come to this pass. We don't want to be sitting here in opposition. We had a cordial, as the terms of reference, a cordial, we thought mutually supportive and constructive relationship while the review was going on.
Now, it's my understanding from it that, okay, you said you've met with them, they outlined concerns they had from the report, and you were going to redraft. So there was 3 redrafts, am I correct in asking that, of the report?
Yeah.
Can I ask you, was any of the changes requested, were they significant changes? Were they made a real difference to that report that the board came back with?
No, we went overboard in our responses trying to meet their concerns. So we tried very hard to meet their concerns. A lot of the suggestions they made to us is they wanted us to refer to policies and developments that took place after the review was completed. So we said, look, we're prepared to say that's happened. We can't really make an evaluation of it because we haven't seen it. And there were some matters, as you know, I've done this a lot in other contexts. You would expect to get some factual accuracy, facts back that we hadn't probably understood. So there were a few of those. But we were quite surprised that there wasn't anything substantial. And when I I had a conversation with Ursula when she spoke to me about her concerns on the phone. She said to me in terms of the concern wasn't really about the factual accuracy of the report. It was, I think, more about they hadn't expected something that was going to be critical in some ways.
Right. So do you think that the reason for this non-publication of this report is that it may reflect poorly?
Well, no, I mean, as you know, I've been responsible for doing evaluations of juvenile establishments in the UK. It's very difficult to run these things. It points out that there are a lot of difficulties and that things that could be done better. But I wouldn't say on the scale of it, I'm quite surprised at the reaction. It's not, but there are things of concern that need to be addressed. And what's really clear to me is you won't, simply looking at the recommendations won't help you. You need to understand what is the problem that the recommendation is trying to fix.
And that's the question I want to ask you, right? We were given recommendations, 9 to 5, right? And we're given and some of them, I'm going to be honest with you, when I was reading the recommendations, I was really, really concerned with. Right, so there was some of them there, recommendation 82 about cavity searches, right? So I needed to know in what context was this recommendation put in. Now, since then, the board has submitted us with this doesn't take place, blah, 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 and, you know, regarding the recommendations. But from an outsider looking in, seeing recommendations that I don't know what this refers to. So I just have to be on the record of asking, these recommendations, were these practices in place in Oireachtas when you were doing the review?
You have to look at it. Of course, it was different in some cases. Some were things that were being talked about. I mean, I think we've talked about this. So you'll appreciate our view is that it should be the Oireachtas board that published the report. And we've been very consistent about saying we are going to keep our side of the bargain. We're not going to say what's in the report until it's released, and I wouldn't want to do that. But what I would say is this. I think, in common with lots of establishments of this type, there is a distinction between what the policy is, and often indeed what managers think is happening, and what's really happening on the ground. And so we found a number of examples where there was that difference. This is clearly what's happening, and this is kind of what you think is happening, and there's a gap between the two. Now, that's certainly not a problem unique to Oireachtas. That's very consistent with those sorts of closed establishments. And it's important, therefore, so in some cases, simply saying, OK, our response to this recommendation is we're going to produce a policy on X, doesn't really address the issue unless you are clear about, well, like, what wasn't happening before, do you accept what wasn't happening before, and therefore are you going to be able to do something different this time that will address it? And quite often, I think, what's happening in Oireachtas is that the written policies were great, but that wasn't what we found was actually happening on the ground.
Wasn't implemented. So just finally, can I just ask one last question around this? You'd indicated that you weren't allowed, you didn't get back to debrief the staff, and that's really important that the staff, you know, Oireachtas are supported and know what was going on. Were you given any reason?
I mean, the first thing to say there, we were always absolutely committed to returning, and we retain that commitment to this day. There were a series of delays that are outlined in our written submission to the committee that were pursuant upon the chair of the Board of Management and the director wanting additional time. So the date that we'd originally scheduled to return to the campus and meet with the staff had to be pushed back. At the point at which we submitted the report, it was very clear that the chair of the board and the director were raising issues. So it raised the question, what is it we're reporting back? We'd kind of assumed we would be able to report back on what was contained within the report. But if the report was effectively being suppressed, it would be difficult to address the staff group. But we retain that commitment, and it's stated and restated on several occasions in writing, including, if I may say so, on March the 17th, 2017, when we wrote to the Minister, we restated our commitment to returning, and we said that we were awaiting an invitation to do so. that invitation has never been forthcoming. There was an event organised by Oireachtas of May, I believe, of 2017, in which the report was discussed to various stakeholders across the country, but we weren't invited to attend that event.
Okay. Yeah.
Thank you, Deputy. I now call on Deputy Rabbitte.
Thank you, Chair. Thank you, gentlemen, for your presentation here this morning. I suppose one of the reasons I would have requested that you come before us is to get a real understanding from your point of view, because you haven't had that. And from my analysing of it, I think what you had conducted in Oireachtas was a root and branch review of Oireachtas. And of course you would have to have taken in policy if we were to move forward, if we were to learn from it. And see, it's not in context when you have all the recommendations there, if you don't know what policy and who is responsible for what. That is just it. But there's 285 paragraphs, 285 paragraphs in it. Now, as you said, out of all of that, there possibly was 4 paragraphs that might need to be parked aside for it to go ahead. Now, when you talk to the Minister over and back and everything else like that, initially your first conversation with the Minister, she understood where you were coming from, because I would have thought that's what was required at that point in time in Oireachtas, was a branch and root review of everything from start to finish. In what context, when you had that conversation with the Minister in December 2017, or 2016, sorry, 2016, did you get the opinion that this is what she had wanted, and this is what was requested by the Oireachtas committee, this is what the board and the chair of Oireachtas had bought into? And I also want to know, at any stage, had you involvement with TUSLA in all of this?
Let me, if I perhaps deal with the ministerial point first. Then
yes, please.
On the ministerial, I made a contemporaneous note of my conversation with the minister. And amongst the policy issues we then talked about is, one is whether that in addition to Oireachtas, there should be some smaller units elsewhere for some of the most vulnerable children. We talked about the use of remand. We talked about 17-year-olds who at that point weren't in Oireachtas being moved. I'm not sure what's happened. And we talked about the detention of girls. All of those were national policy issues, and she also talked to me about the governance structures within Oireachtas. So we had a wider, so we had quite a wide discussion. She'd wanted to know what the review was going to say, so we talked about some of the, in a sense, of things that were internal to Oireachtas, and we talked about some of the wider issues. I didn't have any sense from her, not only did I not get a sense that she was surprised we'd cover that, my impression at the time was that's what she wanted to know, what we thought about those issues. So for now to be said that that was outside our terms of reference, I don't follow that. Can I also just deal with your point about the paragraphs we offered to redact? Mm-hmm. One of the things that we've been very unclear about right from the start, and I have to say we aren't really clear about now, is what are the legal issues about? So our first impression, that wasn't spelled out, it seemed to be referring to the trials of some of the boys who've been involved in disturbances. So, and we recognise that perhaps we shouldn't include that. So that was issues relating to that were the paragraphs that we thought we should take out. Then it seemed to be about the process of consultation and whether the procedure had been fair. So actually what the legal issues were seemed to shift, but I have to say we still have not been given not been told clearly what they are. If we knew what they were, maybe we could address them, but we don't know what they are.
I'd say, if you don't mind, Deputy, I find it extraordinary that the organisation goes out to tender, finds 2 suitable experts to conduct a review of the operation of the facility. Those 2 individuals then go through the process of completing a review of that facility, and then there's a refusal to even inform the authors of the report as to the nature of the difficulties that the report has strayed into. Yeah. I do find that quite extraordinary.
I actually find it
2 years later, we're still dealing with that.
I actually think it's complete and utter madness, to be quite honest with you. We've used taxpayers' money to actually look after a unit, to get a root and branch report around a unit that is to look after our young people, and it's taxpayers' money that funds it all of the time. We have possibly a really good piece of work there that needs to be used, that could be a tool, because I have the HICWA report here, and you've referenced it in your statements in relation to HICWA, and I have pages of where I don't see improvements, even though I'm led to believe all the time. While there have been some, maybe not in the areas that I would like to see improvements, and I talk about mental health, and I talk about pathways for children and the reporting mechanisms, and look at, like in one of the latest HICWA report, why and how was a child left in separation for 12 consecutive days? Like, I would like to hear more in behind it, possibly can't say it, but like the recent HICWA report, if we were to move forward, surely your report would be the tool to be able, be the gauge.
Yes, and I think, you know, we were very, what we were committed to doing would be to return for discussion of our findings and recommendations. And it seemed to me people might have said to us at that point, well, we don't agree with what you said here. We could have had that discussion. They might have said, look, you've got that wrong. We could have had that discussion. We're not. But simply to be sort of floundering around trying to guess what the problem is so that we can put it right, is been very frustrating for us. And you know, to emphasise what Barry has said, if you don't understand, this isn't just about Obistown, in these kinds of issues, if you don't understand and accept what's gone wrong and then you won't do what's necessary to put it right. And that's what we're interested in, is putting this stuff right and learning. You can't learn if you're not accepting where things haven't worked in a way that you want. And just to finish on this, I was responsible for this area over in the UK, and one of the things I always used to say to my teams was, never forget, it's much harder to run these places than it is to monitor and evaluate them. And you need a degree of... I absolutely accept that people running Obistown have a really difficult job. And our intention was, and what we hope we've done, is produce something that would help them in that process.
I asked a question in relation to TUSLA.
Yes, I was just going to come to that, and we did consult with TUSLA and received, I believe, written submission from them. I don't recall, Chair, meeting with any representatives of TUSLA personally. I think, if we may, that's, if the Deputy wishes, that is something we'd want to take away and check.
I know, we tried to fix a meeting with TUSLA and they weren't available in the time we were over at Obistown.
Right, thank you very much. Yep.
Finished, Deputy.
Yeah.
Thank you. And now invite other members to make contribution. Deputy Chambers, please.
Yeah, thank you very much. I know we raised this issue previously, and I just want to put on the record again that I was disappointed that the report was not fully circulated, and just to thank you for your work, and just to agree with the sentiments that if we don't understand the mistakes that were made, we can't really learn from them. And obviously our focus and always our obligation is to protect children and to do our best by them, the most vulnerable in our society. Just to say thank you very much for your work.
Thank you.
Deputy Chambers. Deputy Neville, please.
You mentioned earlier in your report that there was on the lead up to the finishing or the completion of the report. How many times did you meet with the people? You had said that it wasn't flagged to you at any stage that this report mightn't be, or there might be legal implications in relation to it being printed. Was there a specific set frequency of meetings that you would have, evaluation meetings, a step-by-step progress of we're 3/4 of the way through, we're 2/3 of the way through? At any stage, did any of you ask the questions? Would there be any perceived problems or anything like that? You say that nothing came up, but did you ever ask the question that, can you see or envisage any problems that may arise?
If I may take that question, the processes of consultation and communication, particularly with the Chair and the Director, kicked in before we started the operational review. We had a day-long meeting before we started the review. We discussed the way in which we were going to address it. At each of our you'll be aware that we visited Obistown on 2 occasions. At each of those 2 occasions, we met at the beginning and the end of the meetings with the Chair and the Director, both in terms of the beginning of the meeting, explaining what we intended to do during that period of the visit, at the end of the meeting, sharing preliminary findings, preliminary observations. The message we received, the principal message we received was that nothing that we'd found was particularly surprising. We came across some very concerning issues, but the Director and the Chair assured us that they were aware of them and they were being addressed. When we were working to a fairly compressed time frame, when we prepared the first draft of the report, that was submitted to the Director and the Chair, and we invited their comments. We had a day-long meeting in Liverpool with all the data set out in our written documentation. We had a day-long meeting in Liverpool with both the Chair and the Director, in which we went through and discussed in very close detail the report, after which time they submitted their comments. We took account of those comments and provided a second draft of the report. We had a further day-long meeting with the Chair of the Oireachtas Board of Management to discuss those. At the end of that process, this is the second draft, we prepared our final report, and to accompany the final report, we also submitted to the Chair and to the Director a very detailed written document explaining in forensic detail precisely how we had taken account of the issues that they'd raised with us. There were some relatively minor factual inaccuracies, as you might expect in a process. They were put right, and we addressed every single other point. That is not to say we revised the report in precisely the way that was being asked of us, because we were there as independent reviewers. We were not there to collude with the process at Oireachtas. There was some divergence in our views.
Can I just say also what I think is kind of relevant to that is the reasons that we've been given for concern about the report have shifted over time. So first of all, there were these fairly unspecified legal issues. Then there was the question of...
Sorry, just to cut across, was that through the process of consultation, or was that at the end when the
this
final
is after we'd done the drafts, and then we have a set of... Then we have these different explanations as to why there are concerns about it. They weren't concerns, as I said, that were raised with us at the time, either when we were meeting with them directly, when we were asking for information.
So this was after the final draft was submitted, then you started shifting?
After the final draft was submitted, we had explanations, we had accounts of why it couldn't be published. In the process of producing, in the process of doing the review, we had this detailed discussion with them and exchange of correspondence about what the review would cover. Every bit of information or person we met in the review, we arranged principally through Mr. Bergen. So we would say to him, we'd like this information, or we want to see that person, and he or his staff very efficiently arranged it for us. At no point was did they say to us, why are you seeing him, or what's that about? Right? For instance, there was an occasion where one of the minister's officials wanted to meet with us, and we were asked whether we wanted to meet with her. We said, yep, because, our reply said, yes, because we are particularly keen to deal with some of the national policy issues here. So there was never any, we were flagging absolutely what we were looking at and what we were doing. There was never any suggestion, hang on a minute, you're going off track here. And as I said, we met with Mr. Bergen and Mr. Kelly at various points in the review and told them about what we were finding. And their view was, yep, this is consistent with our own concerns at that point.
There's just one final point. You said there was inconsistent, obviously there would have been to and fro and inconsistencies and they shifted. Did that get progressive as it went on? Or did it, you know what I mean, like did these inconsistencies, you said they shifted, but did the amount of those inconsistencies increase in volume? Or was it just moving from one inconsistency to another?
At different points, we've been given different explanations as to why the report can't be published.
Okay. All right, thank you.
And just to reiterate on that, I have to say that none of the explanations are terribly persuasive.
That's to put it mildly, Professor. Just before I ask Deputy Daly to make her contribution to the committee, I just need a little bit further clarification. The board has stated that they believe that fair procedures were not applied in the context of the process of compiling the report, and yet it is my understanding that you were not permitted to follow up with individuals who are cited in the report. Am I interpreting that correctly?
Well, first of all, we're not clear about in what way fair procedure. We don't understand what that means. We are. There are two things. So one is there are no individuals referred to in any way that we think could be interpreted as critical in the report, apart from possibly the chair and the director. Right? And both of those we had detailed meetings with. So if there's someone else who they think might have been not given an opportunity to respond, we don't know who that person could be. And if we were told, then we would have to consult them. There's a second issue about our contract made a commitment for us to come back and share our findings, so not consult about the report, but tell them what we had found with the staff and other stakeholders at Oireachtas. We repeatedly said we couldn't do that, but of course that wasn't a possible thing that needed to be arranged through Oireachtas, and of course we couldn't share our findings if our findings were not in the public domain.
Okay. Thank you, Deputy Sherlock. Yeah. I'll let Deputy Daly in at this point. You're very welcome, Deputy, please.
Thanks, Chair. And actually, probably a little bit like yourselves, we've the same questions you have. So I feel in some ways a bit pointless asking you questions. But I would like to say that, I think you've been incredibly forthright, consistent and clear in all of the reports that you've given, and indeed in your testimony today, and your independence and professionalism really rings out. And I suppose our job here today is to get to the bottom of the reasons for non-publication. And as you say, there's been 4 different reasons given at different times, none of which really stand up to much. And we're here to scrutinise that, but that'll probably come in the later part rather than here with yourselves. So I don't want to repeat points, but just to get a couple of things clear. Firstly, around the fair procedures thing, because this is something that a lot of play has been made of both in the House, and we see it in correspondence that was released under FOI and that as well, fair procedures, concerns about this, people having the right of reply, all that sort of stuff, I suppose one of the first things on that, during your last visit to Oireachtas, now this is prior to publication, on the 8th of November, I think, 2016 was your last visit. Had she expressed at that stage any concerns to either senior management or anybody in the board about what you'd uncovered in the visits at that stage? Yes. We know, like from the chair said, you didn't formally present, that's fine, but did you give an idea of your concern?
Oh. For example, while we were there, we were so concerned about what was happening to one child, we made a safeguarding referral during the visit. So they can't have been in any doubt that we were concerned about things. And we've had that. It is true to say that we didn't, obviously at the end of the visits were very concerned with the review process itself. So we didn't have a very long feedback process at the end of the visit, because Barry and I needed to put our heads together, go through the material and come to our conclusions. So there wasn't, but they can't have been in any doubt about the concerns about what we were concerned about.
I suppose that's the issue I'm trying to get at, because the chairperson is on record as saying that when she got the report, it landed like a bombshell. It was a total shock when she saw the report. But that wouldn't seem to tally with what you're saying.
Obviously, you'll be meeting with the chairperson later, and you can address that question. But the one issue that was stated to us was that the report was longer than they expected, and the reason it was longer than they expected is because we were told, we learned, and we observed practices that troubled us to a significantly greater extent than what we'd originally anticipated.
Perhaps I could also just add to this. I think the Minister has herself now been clear that there was a fact-checking process that went on, and the suggestion that didn't happen was incorrect. I think that I don't think the fact that our report came as a bombshell to people, if it did, to people at Oireachtas is a reflection of the way on us in the process of producing a report. I think it's a reflection of what was happening at Oireachtas. And while the chair and director told us, yes, we know about this, we know about that, that's a different thing. When these things are set out in some forensic detail with the supporting evidence that does that, I think that would have there would have been bits in that, there would have been some pretty hard reading. I'm sure about that. And I'm sympathetic to that. It's not, you're sitting on top of it and, generally saying, yeah, we know we've got some problems, but something that then spells that out and perhaps says stuff you didn't know, you thought you'd fixed, but actually isn't fixed. No doubt that was some hard reading, but that wasn't a reflection on our lack of consultation.
I think that's an important point, because the interpretation of that statement, it's been posed in the context as if that you were kind of off the beaten track, that you had come up with stuff that was, completely out of whack, and threw everybody, and that was a contributing factor to. But what you're saying is it could have been shocking if the people reading the report were disconnected from the reality of what was happening in the organisation.
Let me be really clear. One of the things I am really clear about is the quality of our methodology. We spent, in a sense, the more serious some of the concerns we identified, the more care that we took. Right? So we used the classic multiple evidence triangulation process. So we looked at data, we looked at what people were saying to us, we looked at the boys were saying to us, we looked at what staff were saying to us. We pulled the evidence, we looked at what we were observing, and some of the stuff we actually saw with our own eyes. And we're very confident about the accuracy of our report, which is why, in the end, they didn't really raise any significant issues of factual accuracy. We're very clear about the accuracy of what we said. If that came as a shock to people, that's revealing, that in itself is an issue that Oireachtas need to address. Why didn't they know this stuff? If they didn't, it's not a reflection on our report or methodology.
I think it's key that point was brought out, because we know from FOI, for example, in correspondence between the department and the chair of the board, it refers to actually the chair of the board questioning and raising concerns about the lack of consistency in your processes, and that she had concerns about the methodology that you had adapted. That was so. I mean, you've dealt with that point very clearly.
And I think that if I'm surprised that officials or ministers, if they had these reports about concerns about our methodology, they didn't come to us and say, look, we've got this issue that you didn't do this or you did do that. What's your response? This is, why we're grateful to the committee. This is our first opportunity. We've really had to put our account of what we did down, and I think we could have.
I think, in fairness to the department, there was a lot of follow-up correspondence where they were in dialogue with the board or trying to overcome the board's objections and push them along, and that came afterwards.
Yes, we only saw that when we got sent
defend the department, but
to be fair, we weren't aware of some of that stuff happening in the background.
But I think it's important that you made that, because you see, there's a school of thought, not mine, I might say, but I've heard it said, or hinted, if you like, that the two boys are in town kind of blow-ins kind of came in for a few days at a time when the campus was going through a very stressful period, was busily implementing changes, things were difficult, and it's all very well for you to come in for a couple of days and have a little look and talk to a few people, but that the job was being address. Now, I don't buy that. I don't in any way accept that that's a reason for non-publication of something in the public interest, because if the work was being done, great, admit it and show where. But how would you respond to that view that publication would impede that good work, that you were just there for a bit, hard times, and they were getting down to the job of work?
If I may say so.
Stop laughing.
The first thing about recognising that the review was a fairly compressed process, that it's occurred against a backdrop of acute instability at Oireachtas. All of that is explicitly laid out in the introduction of our operational review. We explicitly state that these were exceptional times. Notwithstanding that, it's extraordinarily complacent to assume that it can all be fixed, and it has all been fixed. And I've looked at the HICWA reports both for 3 years previous to the operational review and indeed to the HICWA reports that have been published subsequent to the operational review. And there are some very consistent problems. And they're the lessons that have to be learned, and they're the lessons that we believe our report will assist.
Well, that's exactly, and that was my next question, because it is the case that you've said it here again, that the review that Deputy Rabbitte referred to in 2018 resonated a lot within your report. Now, obviously we haven't seen your report, but we're deeply concerned about what the HICWA report has said. Obviously the Minister has said that report was a great success, it shows the progress, but it found that only 3 standards out of 10 were compliant. Fully 5 of them were non-compliant, including care of children, safety and security, dealing with offending behaviour and staffing and management. And I suppose a particular concern is that very unusually HICWA singled out an individual for criticism in its 2018 report. So I suppose what I'm looking to know is can you give us a bit more information on the parts of the HICWA report that resonate with yours, without compromising information you don't want to give us? Does the HICWA report reassure you that the issues that you flagged in 2016 have been addressed? Because that's critical, obviously.
No.
And that could not be clearer. So,
can I just add one point, a question you asked earlier, just very briefly. This idea that we were only looking at what was happening in the 2 or 3 days that we were there, right? That's not correct. In terms of what we observed, that was happening only when we were there. But of course, what we were getting systematically in different ways from staff and from young people and from external stakeholders is what had been happening over a period of time. And of course, the data we examined went back over a considerable period of time. So we were not simply looking at that snapshot at a particularly difficult time. We were looking at a wider period using a range of evidence, much of which supplied by Oireachtas itself, that gave us a longer-term picture. I think that's so. This idea that, it was different the day before and it was different the day after we were there, that's not correct. And I think, as the HICWA report demonstrates.
I think that's really important that those issues will be clarified. My last point, I think you've been clear that you've been open to coming back and still are talking to the staff on that one, and you're open on your and you have suggested arbitration, haven't you? Actively suggested it and agitated for it. Okay, my last point is just because one issue that was of constant concern to me is the statements that you've made that had the contents of the report been made available, that the outcome of some of the legal actions in terms of the young people might have been different.
We don't know what we don't know, really, so we are not saying that that material is relevant, but we are saying that the should have been available in a legal process so that people could have decided whether it was relevant or not.
I don't want to stray onto matters that are ongoing, so we need to be careful there, but yeah.
Case are over, but yeah.
So, but just we're not saying it is relevant, we're saying we're worried we don't know that it's relevant.
Yeah. May have been. It may have been.
That's understood.
Yeah.
Can I just ask one question just before I let Deputy Sherlock come in? Have you had contact with members of staff since your report was sent to the Board of Oireachtas? Follow-up discussions?
Only the Director.
No.
Just the Director?
I think actually we set up part of the process, we agreed with Oireachtas, is that we set up a confidential email service so people, staff could write to us directly.
Very good.
I think it's true to say some of those actually came in after we'd finished the review, but not not saying anything about what had happened subsequent to the review.
Okay, no, that's fine. Deputy Sherlock, then Senator Warfield.
Thank you, Chair. I'm delighted that you're both here today because this has given us a lot of clarity and it probably has answered some of the questions that we've had in our own minds in respect of the processes that were undertaken. I should also say, if you haven't been told already, that we have not had access to the report. We have not seen the report. I have not seen the report.
We have been told, Been told
Okay.
that.
Okay, so we are flying blind in this committee. We have a sense from the Minister's interaction with us previously, prior to Christmas, that the HICWA recommendations are being worked through, and I certainly had the impression from the Minister at that interaction with the Minister at the committee that that was as a result of work that had flowed from, you know, your report. So my questions are about the terms of reference. We have an impression, or we've been given an impression, that observations were made by yourselves outside of the terms of reference of the report. What is your view on that? And I'm quoting the Minister directly.
Our view on that is we don't know what that refers to.
Okay.
So we did spell out, and we've included in our submission, this very detailed memorandum about what we would be looking at. At no point was there comeback. Every bit of information that we looked at, we obtained through Oireachtas, so they knew what we were looking at. The recommendations have been published, so I don't, and indeed the Minister made it, asked me about some of those white restrictions, so I don't, personally, I don't understand what that's about. And frankly, if there's something outside the terms of reference, well, maybe that is something that should be redacted or whatever. I don't, but we can't deal with it if we don't know what it is.
Okay, well, in response to a question from Deputy Rabbitte at the last committee meeting, the Minister stated, and I quote, that the report was written and conclusions, observations and recommendations were made. I answered Deputy Rabbitte's question about observations made that were outside the terms of reference and which went into policy issues. It was not provided for Oberstown House for people to review. People may have been named. So people are named within the report. And forgive me if you've answered this question already.
We're not aware of naming any people in the report, other than the Director and the Chair.
Okay. So on that basis, if I may, on that basis, do you see any impediment why, in the public interest, this report could not come into full public view?
No. And just a minute, we're also open to redaction. If, for instance, I don't know, that we put in something that might be then interpreted as a critical reference to someone that we haven't understood that could be interpreted in that way, then we'd be happy to consider redacting it. We haven't got red lines here. We're happy to look at those issues, but we don't know what they are.
Okay, well, again, I'll quote from my own question to the Minister at our last committee meeting about this, and I asked the Minister, was the process designed in such a way that if findings were made against persons or the entity, that there would be a right of reply? The Minister said yes, they were asked to provide the report for the people concerned before there was a final report, and that is what I'm saying. You, from what I've heard so far, are satisfied in your own minds that that actually took place, and that you openly said that if anybody wanted to discuss the findings of the report, that you would make yourselves available to do so.
We went through the most rigorous and consistent processes of consultation and communication imaginable at every single stage of the operational review. The one omission that the terms of reference refers to is returning to Oireachtas in order to share our findings with the staff and the key stakeholders. And with respect, we've addressed that question already. I'm happy to repeat it, but we've addressed that question.
Well, the Minister did say, following that...
And we're still open, we're still very open to doing that if Oireachtas feels inclined to invite us.
Well, the Minister said that the Oberstown Centre envisaged that the visit would take place before the reviewers finalised the report. That was included in the terms of reference in order that comments could be taken into account in the final version of the report. However, the reviewers maintain that it would not have been possible to provide feedback until the report had been completed. Is that what the Deputy wants to have published? The reviewers consider it to be final. So I suppose what I'm trying to reconcile there is, and I know you are repeating yourselves, is that while we have not had access to the report, and we do have access to the recommendations, and we know that HICWA has had access to the report, and that there's a working through, because ultimately what all of this is about is to ensure that Oireachtas is fit for purpose, and that, you know, the people there, that there is, you know, robust procedures and protocols and standing operating procedures. But if there is still a sword of Damocles hanging over Oireachtas in respect of this report, I suppose what we're trying to do is to tease out whether or not the fair procedure that the Minister tells us about in this committee and the advices that she has in respect of publishing the report, because she hasn't published the report, so therefore there must be advices to the effect of saying do not publish. We're trying to reconcile ourselves with the fact that the public good to our minds is not being served by the non-publication of the report to date.
What I think is frustrating about this, first of all, we are not aware of any individual that could be said to be criticised in the report that hasn't had an opportunity to respond to it. If there is, we'd be happy to consider that. What I think is very frustrating about this is that after we submitted the first draft of the report, where we had these two lengthy, practically full-day meetings, first of all with Pat and Ursula, then with Ursula alone, at no point do they say to us there, your procedure is flawed. You need to do X, Y, or Z to make this a fair process. They didn't say that to us. And indeed, when we got the very detailed comments back from them, which were largely about post-review events, and we sent our reply, at no point do they say then, well, hang on a minute, you haven't given X or Y a chance to reply, right? It was only months later that this issue arose. Okay. And it still remains. And I should also say on all of this, you know, we've kept every bit of correspondence on this, so and we're happy to make any of that available to the committee if there's some doubts about what we're saying.
So do you think that the Board of Oireachtas would have nothing to fear from the publication of the report?
Well, it would. I think it would,
I mean, from a personal,
you know, the board
responsibility.
Well, I don't. I mean, well, I think that the when we were asked to do the review, both the chair and the director were very clear to us at that time that Oireachtas was having a lot of problems. Yeah. They weren't saying, look, you know, it's all fine here. They were saying we're having a lot of problems when you come in. Now, clearly, the people with responsibility collectively for Oireachtas will be looking in that report, and as I said, I think it would make some quite uncomfortable reading. So, you know, but we haven't named individuals. So if I were on the board of Oireachtas, my reaction to it would be, yep, it would be uncomfortable, and I'd want to get to grips quickly with trying to sort it out and make sure it doesn't happen. I don't.
Okay. So the final question.
Last question,
yeah,
please.
thank you. The methodology, because you are both academics, and we in this House, most of us are not academics. We would have interfaced with academics. And so the methodology, can you give us confidence that the methodology that you used, you know, is in line with best international practice?
Yes.
I'm not questioning your bona fides, because there may be others who will come before this committee who might seek to or question the methodology. I want to be sure in my mind that the methodology is robust.
I've only recently started a life in academia. Prior to that, I was Her Majesty's Chief Inspector of Prisons in England and Wales, responsible for inspecting youth custody. The Inspectorate was the lead body in the UK's National Preventive Mechanism, established under the Optional Protocol of the Convention Against Torture that I know Ireland is considering. And now part of my academic work is teaching and acting as a consultant to governments and bodies around the world about precisely these issues. So I do think I have expertise in this, without meaning to sound boastful. And I'm very confident about the process we used in this measure. And I have to say, looking across the world, some of the, in a sense, the obstacles that the concerns we've run into here happen elsewhere. That actually people think they know what's going on and they don't. I do a lecture about the process whereby poor practice becomes normalised. It becomes the way we do things around here, and it takes somebody external to say, hang on a minute, that's not right to us. There's a distinction. I talk about the virtual prison, by which I mean the prison the governor thinks they're running, which is very different from the prison that's actually happening on the wings. You know, there's a distinction between the policy and what's actually happening. Some of those things, and when you read that, if you're responsible, it can be uncomfortable. But you won't address it unless you accept it.
If I can add to the methodology, I mean, I've been working in universities for 25 years internationally, and I've sat on review committees for research methods, again, at very high levels in universities internationally. And if the committee requires assurance, I can give you absolute assurance that in the time that we had available, the research design, the review design, the method and the forms of analysis were absolutely rigorous and conformed with international standards.
Thank you very much.
Thank you very much. Can I now call on Senator Warfield, please?
In all your time monitoring institutions and writing reports, have you ever experienced anything like the breach of contract? That is your contract with the board?
I've not done it in quite this kind of way. I mean, there would be agreement beforehand if I was doing it in other situations about whether something was going to be published or not. I'm not used to this. And certainly when I was Chief Inspector of Prison England and Wales, the reports were published at my discretion, not the discretion of the institution. And, we'd go through a fact-check process, but then we'd publish it, and if they... And again, I'd be quite robust. Sometimes people would argue, and that's fine, if they don't, but...
Somewhat different, respectfully, Professor. You were performing a statutory function.
Yes, exactly. Of course, I accept, you're quite right, Chair. Of course I accept that. But to answer the question, I'm not... I mean, something, we had a very clear contractual commitment that the report would be published. So that's an, and that if we couldn't reach agreement, there'd be arbitration.
Precisely. And both of those conditions have not been observed.
So you don't regret in any way that you didn't ensure that it was your discretion that the report would be published?
Well, as the Chair said, we didn't have a statutory function. We don't have a statutory function here. In the end, we've always been clear. The publication of the report is ultimately a matter for the Oireachtas Board. We are not going to go off course and do something ourselves. We've been very discreet about it. We are, in the end, it was a, we were doing a contract, but that we wouldn't have entered into the contract if we hadn't had agreement that the report would be published. And because we gave assurances to the people we were dealing with that it would be. When we were interviewing people, when we were talking to them, we told them in good faith that's what would happen.
In light of how alarming and serious this is, and you've spoken about the principle of transparency, accountability, the public interest, the common good, what have you considered or thought about what position you'd be in if you left the report at the door at Tusla?
Sorry?
Have you considered what position you would be in if you left the report at the door of Tusla?
Well, yes, we've considered that we aren't going to do that. We think it's for Oireachtas or the authorities in Ireland to publish the report, not for us. And we've been very careful that we will abide by our side of the contract, and we want to be able to look people in the eye and say that's what we've done. And it's noteworthy, I think, that there hasn't been any suggestion the report's been leaked. We haven't done that.
The Director says, and you've matched that with your own statements, that you met in Britain in 2016 and that they highlighted factual inaccuracies. Were there many changes made at that point, after December 2016?
There were some changes made to the report after two processes of consultation in the way that we've described to the committee. The actual factual inaccuracy question was few in number, but inevitably there will be issues about accuracy that need to be corrected, and they were all addressed.
It's basic stuff. The report informs the recommendation, in this case, the recommendations. In this case, 95 recommendations. Are you aware of which areas of the report then suddenly required legal advice according to the board?
No, we've never... The question of the legal concerns have never been explained to us, and if I may say so, in the committee of December 18, the Minister also appeared to imply that the legal concerns hadn't been explained to her either.
The Minister appoints, 12 members, ordinary members to the board. The board includes reps from the Department of Children and Youth Affairs. Is there anything to suggest to you that the department has had an overreach or any influence in the attempts to bury the report?
We haven't seen it. The only material we've seen about some of that is there's some material released under an FOI request which we looked at. I mean, in a sense, we're not aware of what's going on behind the scenes. And again, as I repeat myself, frustration is if we knew what the problem was, maybe we could have done something about it.
What would you say to ministers upon? What would you say to ministers upon?
We think the report should be published.
Thank you, Senator. Any follow-up questions from members? Quickest hand up. Deputy Sherlock. Please, Deputy
No.
Please go ahead.
It was just to follow on from what the Senator had said there. You just finished it very curtly. You think the report should be published. Why?
For all the reasons that we've described. I mean, and principally, well, for the four reasons that we described. To honour the terms of the contract, to respect questions of transparency and accountability, to serve the public interest, and to, perhaps most importantly, to ensure that the lessons derived from the report can be put to best effect.
That for me is the key thing. You have to understand what went wrong, where things had gone wrong, in order to fix them. And I think, even if it's the case, it would be very good if Oireachtas has subsequently improved, but still, clearly there's a way to go, and that needs to happen.
That was it.
I think for Gray, as Deputy Mitchell mentioned, the abstract nature of the recommendations as a separate entity, completely separated from the body of the report which provides the detail. And it's very difficult for us, as we have expressed at previous meetings on this subject matter, to do our jobs in the function of oversight of both the department and Oireachtas without seeing the nature of the difficulties and the campus.
Of course, we hope that the Minister will agree to make the report available to people like this committee. I mean, I wouldn't, just to be clear, we have absolutely no objection to anybody seeing the point. And we would be happy to sit down and talk about it. I mean, one of the things that I think is, we could sit down with the Minister and talk about it and as I say, talk about if we understood the concerns, we could maybe help resolve them.
Thank you. Deputy Sherlock, please.
Your point, Professor Goldson, about the Minister's interaction in respect of the legal advice, and I'll just go back and quote directly what the Minister said. I have indicated in terms of the legal advice as well as the experience of the board, the staff and my officials, that fair procedures were not followed. And therefore, there is a lack of fairness there, which leads to the legal risks, which is why there is not a publication. I think what you're saying, and I in no way wish to put words in your mouth, perhaps you can enlighten us. Do you agree with that statement?
No, we strongly dispute that statement.
Okay. So there is no reason, from a legal standpoint, why the report could not be published.
Well, we simply don't know. I mean, we are aware that Oireachtas commissioned counsel and took legal opinion, and it was communicated to us that there were perceived risks. The nature of the risks and the question as to who might be affected by those risks have never been explained to us.
I think it's important, actually, evidence to put on the record, just for anybody who might be watching these proceedings, that the legal advice with regard to your report cost the Exchequer €26,000, which is actually exceeds the total cost of the report by €10,000. So we're now talking about €40,000 worth of product which has not been provided to the public. And I mean, I think it's perfectly justifiable for all Oireachtas members here of all parties and indeed none to be able to stand over expenditure within the department over which we have oversight. And I certainly can't, and I'm sure that my colleagues can't either. So
It's not, because also it's not clear to me about whether the legal advice is about somehow or other that we didn't follow fair procedures, or whether it's about some other matter. Because if you look at some of the initial comments about legal advice, they didn't seem to apply to they seem to be distinct from the fair procedures.
Well, to be helpful, Chairman,
Go ahead.
the legal advice to the Minister is from the Attorney General's office. And we do not, as a matter of fact, have access to that legal advice in this House. And then, therefore, one can make the assumption, absolutely, that the representatives of Oberstown do not have access to that legal advice either, because that would be contrary to the law, if you will. And on that basis, my understanding is that the Minister has the discretion, on the basis of the advice, to publish or not publish. She has the ministerial discretion to do that.
Absolutely she does.
So I think what we're hearing here, based on, what has been an enlightening interaction with yourselves, is that there is now a clear need, Chairman, for this report to be published and put it out there in the public domain, so that those questions which arise, can be answered satisfactorily. We can all, in this committee, make some determination as to our interpretation of matters, if you will.
And as to add to that, I think that would be helpful. And if there's any, for instance, if the committee subsequent to our appearance wants further information or clarification from us, as I say, we have very detailed records, all the correspondence, so we can do that if there's any doubt about what we're saying.
To be fair, you've been transparent and open.
Indeed.
Couldn't have been more helpful. There's, we were when the Minister was here previously, we all were very critical that the report was not before us, that it was not published. I don't think anybody accepted the explanation for non-publication, and it was that prompted your appearance here today. And certainly, I think citizens looking on this could certainly draw their own inferences as to why the report is not published. And it's possible that perhaps, the wider public might feel as though something is being covered up. Now, we don't know that. I'm just merely putting it out there, that people may feel that it's, that not publishing the report is to protect the wrong people, that the protection of children is being put to one side, and
Absolutely.
the protection of those that are there to care for children is being prioritised. But in any event, that's just what some might say.
We're, as I said at the beginning, we're sorry it's got to this point, and we are, very keen, if there's some arbitration or whatever, that we can come to a constructive solution. This, our concern is to provide a supportive report that is critical in parts, so that people can act on to make improvements for the children and the staff that are there, and the help the leadership of Oireachtas make it the world-class facility they want it to be. That's what we're trying to do.
Well, thank you
Thanks very much.
to Professors Goldson and Harwick for your contribution this morning. I think, as has been stated by Deputy Chambers, your contributions have been absolutely forthright and very beneficial to our consideration. It would be unsurprising for you to hear that this committee believes, and on all of their behalf I say that this committee believes that the non-publication of this report, of your report, stands in our way in terms of the performance of our function as members of this committee, in terms of the oversight of the Oireachtas campus. And I believe that your report, given the volume of legal advice that's been provided to the board and to the Department of Children, but not to you or to us, presents a severe difficulty to us in the performance of our duties. But I thank you very much for your presentations this morning. I propose that we suspend for 5 minutes to facilitate the changing of our witnesses. So I would suggest that we resume at 11:20 with the chairperson of the board, Ursula Kilkenny. Thank you very much, Professor.
Thank you, Chair. Thank you to the committee for the
Don't come over for a second.
Thank you very much. I wish to again advise members that while there have been reports in the media in connection with the Operation Review report, it is important to note the committee cannot discuss individual cases, should avoid naming individuals, whether these names are in the public domain or not, and should not discuss anything which is or is likely to be the subject of court proceedings. Members are reminded that there are ongoing legal proceedings and that they should avoid saying anything that could have an impact on these cases or seen to interfere with them in any way. Members are also advised that the Operation Review report cannot be discussed and that should be mindful of the legal issues surrounding the report. I would like to welcome Professor Ursula Kilkelly, Chairperson, Board of Management, Oireachtas Children Detention Campus. Professor Kilkelly is accompanied by Ms Emer Woodfull and Mr Donald Leary, who are members of the Board of Oireachtas. You're all very welcome and thank you for coming before us. I again would like to welcome members and viewers who may be watching proceedings on Oireachtas TV to the public session of the Joint Oireachtas Committee on Children and Youth Affairs. Before we commence, or continue I should say, in accordance with procedure, I am required to draw attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect to their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name in such a way as to make him, her or it identifiable. Members are reminded of this long-standing parliamentary practice to the effect that members should not comment on, criticise nor make charges against a person outside the House or any official either by name or in a way such to make him, her or it identifiable. May I remind members and witnesses to please switch off your mobile phones as they can interfere with the sound system and make it difficult for parliamentary reporters to report on our meetings. Television coverage and web streaming can also be affected. I wish to advise our witnesses that your submission or opening statement that you have made or that you will make to the committee will be published on the website after this meeting. After your presentation, there will be questions from members of the committee. I now call on Professor Kilkenny to make your opening statement. You're very welcome, Professor.
Thank you, Chairman, and thank you for the invitation. As you know, Chairman, I sought this invitation, so I'm very grateful for the opportunity to speak to you all today about this matter. I was appointed Chairperson of the Board of Management by Minister Zappone when the new board was appointed to the Amalgamated Campus in June 2016. I am a Professor of Law with over 20 years' commitment and experience in the areas of children's rights and youth justice and detention. In addition to my substantial academic and research experience, I have for years worked on matters of national policy and international law, undertaking multiple research projects commissioned by national and international bodies. I fulfil my voluntary responsibility as Chairperson of the Board of Management of Oireachtas on top of my full-time university roles, and in doing so I'm very grateful for the support of my employer, University College Cork. I appear before you today with my fellow board members, Don O'Leary and Emer Woodfull. The board has 12 members, as you know, appointed by the Minister for Children and Youth Affairs, representatives from the Department of Children and Youth Affairs, from TUSLA and the Department of Education and Science. There are 2 elected staff nominees, there are 2 elected community representatives, and there are 5 members selected following the independent process governed by the Public Appointments Service, all those who have volunteered to be of service to Oireachtas and to the public in this role. I think it's critical to state that all board members have a shared commitment to the interest and welfare of young people, and they fulfil that commitment throughout all of their functions on the board. In addition, many come with very substantial expertise in matters of governance, risk, law, finance and human resources, for example. The board is an experienced and a professional body. It operates to the highest standards of governance. There is excellent attendance and participation by all board members at all of our monthly meetings, and since our appointment we have both supported and challenged management to provide the best possible care to young people in Oireachtas on behalf of the Minister. And we have in that time, as you know, overseen very substantial improvements in the care provided to young people and the organisation as a whole, although of course many challenges remain. When the board was appointed, we were aware that the process of merging 3 schools, a substantial €54 million building project, would be exceptionally demanding. Industrial relations issues, which have been a feature of the schools for many years, created a challenging backdrop to the change agenda that was essential to the modernisation of the entire operation. In fact, on my first day, I attended the Workplace Relations Commission as part of the Director's efforts to resolve differences with staff. It was in the context of this extraordinary change programme and against the backdrop of multiple other reviews that were ongoing under the WRC process into security, into health and safety, into behaviour management and other matters, that the process known as now as the operational review was conceived. It was decided by the board at the time that a facilitated review, the one was based on observation and engagement and other aspects, would help to move the campus forward, to create a platform of engagement and discussion on how best to provide care to young people in a secure environment. So in addition to those multiple other reviews that we had ongoing, the board took this voluntary step to commission its own review, which was, as we know, according to the terms of reference, designed to support the implementation of best practice to ensure Oireachtas fulfils its potential to provide the best care for young people in Oireachtas. So crucially, the review was designed as a supportive developmental process to enable continuing reforms to take place in line with international best practice. And we've heard the terms of reference set out, evaluating practice and policy, identifying obstacles or barriers to achieving greater implementation of standards and best practice, and making recommendations to ensure greater and more successful implementation of these standards. Crucially, and in line with the process as a review rather than the commissioning of a report, the terms of reference explained that the process would follow the following pattern. It would involve observing and engaging with staff and young people, consideration of Oireachtas policies and procedures, speaking with relevant stakeholders, including young people, staff, management and the board and others as required by the review, presenting findings and recommendations to staff, management and the board, and delivering a final report to the board and the Minister. So as the terms of reference made clear, the emphasis was on engaging with staff, young people and other stakeholders, considering the policy framework and reflecting this learning back to staff and management before a final report of the process was presented to the board and the Minister. With the appointment of the two reviewers, who I contacted, one as a colleague in the academic sphere, Professor Barry Goulson and Professor Nick Hardwick, the preparatory visit took place in October, with the 2 days of the scheduled visit taking place on November 7th and 8th. An itinerary of meetings was scheduled for the reviewers entirely at their discretion. They were provided with extensive information on the campus, which they both sought and we sought to provide. The reviewers were free to engage with young people and with staff on an ad hoc basis throughout their visit, and they also received emails to a confidential inbox that Oireachtas set up for this review. At a brief informal exit meeting with the chairperson and the director, the reviewers provided a summary of the issues, but no formal presentation of their findings took place. The first draft of the report was submitted to me at the end of November 2016. Substantial concerns with the report were flagged to the reviewers at that time, and a meeting took place between the director, myself and the reviewers in December 2016 to highlight factual inaccuracies. A further version of the report was received just prior to Christmas in 2016, and in January 2017 I met again with the reviewers to seek to address the ongoing concerns with the report. By that point, the date for the reviewers' return visit to the campus, which was envisaged as a forum to present the findings and to engage with staff and the board around the issues, had passed. The reviewers, in my mind, wanted to finalise the report before undertaking this visit, and it has not, as we've heard, been rescheduled. The reviewers forwarded what they considered to be the final version of the report to me at the end of February, at which time it was flagged to the reviewers that legal advice would likely be required and that a decision on when and in what form the report would be published would need to be determined by the board in line with its legal responsibilities. On the 9th of March, the board decided to independently seek legal advice on the publication of the report, and this was notified to the reviewers on the 13th of March. The report was forwarded to the Minister by the reviewers on the 17th of March 2017. In April, the board set up a subcommittee to deal with the matter, and in May, the independent legal advice was received, following which we sought and received additional legal advice on the possibility of publishing a redacted version and the management of the legal risks in dealing with the matter. On the 22nd of May, at a special meeting of the board decided, in light of the independent legal advice, not to publish the full report. It is important to stress throughout this process the board, which represent a broad cross-section of people with an extraordinary commitment to the interests of young people in Oireachtas, sought to deal with this matter fairly and prudently, but in light of its substantial legal responsibilities, both to young people in Oireachtas and the staff who work there. In light of our commitment to transparency and to reflect the important progress made since the review was commissioned, the Board published the recommendations of the review in July 2017, following a meticulous and detailed process which considered the implementation of each and every recommendation. At the same time, the Board published a summary of all of the reviews undertaken into aspects of the campus, and throughout 2017 I chaired the Review Implementation Group, a group set up by the Minister with representatives of staff, trade union, the Board and the Irish Youth Justice Service, with an independent child welfare expert, collating and analysing the hundreds of recommendations that arose from all of the reviews that we had undertaken in Oireachtas throughout 2016 and 17. This very complex task was completed on schedule in December 2017 when it was presented to the Minister and published by her at that time, along with progress reports that were published in 2018. I'm very pleased to say that a further progress report on the implementation of the recommendations of all the reviews was presented to the Department in January of 2019, indicating that all of the relevant recommendations have now been implemented. The decision not to publish this report was taken by the Board following a process of exceptional care and diligence. This decision was not one that the Board wanted to make. It was its full intention to publish. But we were regrettably left with no alternative when the serious legal risks associated with publication were brought to our attention in the form of independent legal advice. In particular, the Board was advised that placing the report in the public domain would be fraught with legal risk in the absence of the protections of fair procedures and due process that Irish law requires. There is no doubt the campus faced very real challenges between 2014 and 2017 in particular, and these peaked in 2016. Efforts across all areas of staff and management, with leadership and accountability provided by the Board, have played an important role in bringing about the transformative change that has been documented by our statutory inspector, HICWA, following its 2 full 5-day inspections in 2017 and 2018. In addition to the significantly improved environment, the Board has taken a range of initiatives to improve and enhance both transparency and the oversight and accountability that the Board provides, developing and adopting the campus's first strategic plan with the full details of the implementation and the progress of implementation being reported and published by the Minister in December 2018, a communications and engagement strategy, the Oireachtas strategy on the participation of children and young people in decision-making. The review, development and approval of a whole range of policies, an entire new policy framework is under development in line with international children's rights standards and best practice, and first the adoption of a governance handbook for Oireachtas that sets out the respective responsibilities of all the parties. The Board is currently being evaluated by the Institute of Public Administration, another first in the organisation's history. So throughout my time, Chairperson, as Chair of the Board of Management, I have worked consistently and tirelessly with fellow board members to ensure that Oireachtas continues to provide the best possible care to young people. Although many challenges remain, we have, together with staff and management, delivered an enhanced and more stable environment with objectively documented improvements happening across all areas of responsibility. This has been done to ensure that young people detained in Oireachtas now and in the future have the best possible care and life chances. That has been and continues to be our exclusive focus. Throughout this time also, the Board has delivered accountability through regular reporting to the Minister and her officials, to the Oireachtas, through our annual reports and appearances at this committee. This is now my 4th time at this committee, and in many other formal and informal ways. And notwithstanding the very regrettable decision not to be in a position to publish the report, the Board has, through our term, delivered substantial improvements in the transparency of Oireachtas operations. And in that vein, I'm very happy to appear with my fellow board members and will endeavour to answer any questions that you may have.
Thank you very much, Professor Kilkenny. Just from the outset, I'd like to note my personal thanks for you appearing before the committee, and also the fact that you were so quick to offer to appear shortly after, or in fact, if not during, our last encounter with the discussion on this matter with the Minister in December. So I just want to put that on the record. I have just 2 quick points to raise with you prior, just in advance of starting with Deputy Rabbitte, I think. And that would be twofold. The first one is I find it difficult to understand the rationale for preventing the authors of the report from engaging with yourselves as to any concerns that you might have had about parts of the report. both professors went to lengths to repeat that they did not have the opportunity to address any concerns that you might have had in terms of being in the position to redact or remove certain elements of the report that they presented to you. My second question is in relation to the cost of the report or the associated costs of the report. You'll understand I'm also a member of the Public Accounts Committee, and I find it very difficult when I see legal advice exceeding the value of the actual product which was purchased in the first place, in this instance a €15,000 report, or 16,000, well, yes, 15 and change. And we're now looking at €26,000 in legal associated costs. I find that very difficult. I appreciate the board have a job to do, and I appreciate that they're an independent body, but I still find it very difficult to justify that, both as chairman of this committee and as a member of the Public Accounts Committee, primarily because I can't see the product. Deputy Mitchell raised it from the outset in our first session this morning, that there were a number of recommendations, 285 of them. Pages. 285 pages, 90 odd recommendations, and that a number of them are quite concerning to us as members of this committee. But we don't know the rationale for why the recommendation was made. And that presents us with a difficulty as members of this committee who are charged with the oversight of both the department, TUSLA, and indeed yourselves. So therein lies the problem for us as parliamentarians. We recognise you have a job to do. We recognise that TUSLA has a job to do, but we find it exceedingly difficult to do our job because we haven't been provided with the product that you have effectively paid €41,000 for. So those are my two questions to start us off.
I think with respect there's three questions in there, and I might just deal with elements of them in turn. In terms of the legal costs and the overall cost of the review, I completely agree. I have the same concern. In fact, the board has been in discussion about this matter over its last two meetings to ensure that we produce value for money in all of the professional services that we rely on to deliver responsibility and the legal responsibility that we have as a board of management. As you mentioned, we are almost all voluntary board members, but what we have to do is a very serious and very careful job, and we do rely on professional services from time to time. And it's a measure of the gravity of the issues at stake here that we sought to rely on independent legal advice, sought to seek out that advice, and in particular, I suppose, that we were really careful to make sure that we weren't certainly causing difficulties that were going to have much greater costs attached to them in reality. So this was really to be cautious and prudent and make sure we had all the available advice at our disposal. I agree with you about the cost, and it is something we have asked management to review the cost of professional services and the way in which all of that, all the decision making around that, and all, so that is a matter. I share your concern, and it is something we are addressing. In the context of the reviewers' view that either that they weren't able to return to the campus or that they didn't have oversight. In my experience, I would say two things in relation to that. First of all, I would just say as a researcher, and I have myself been responsible for many reports commissioned by bodies who undertook originally to publish, or where there's a discussion about publication or finalisation. It's completely understood that the matter is with the discretion of the property who commissions the report. There is always going to be a process of factual checking and engagement to make sure that what ends up at the end of that process is, if you like, fit for purpose. It's not always possible to get to that point, and in this instance there was, unfortunately, something of a deadlock with regard to finalising the report to a satisfactory outcome. So while what you say is important, it was absolutely the board's intention, and as I as chairperson engaged over and back with the reviewers, seeking to produce a positive outcome. That was the intention, but it was very difficult in the context of the dialogue over and back to see how we would get to that satisfactory point. And I'll come back to the process the board followed subsequently, because it was specifically focused on legal risk in particular. in terms of the rationale and I suppose your general point about oversight, what I would say is that we, first of all, that the report has been seen by HICWA. The board has considered and deliberated over the report and focused in particular throughout this process in the implementation of its recommendations, because that is how you show value for money, in my view, where you run into the kind of difficulties we did. You focus and prioritise the implementation of the recommendations and seek to maximise the positive potential of a process. And I think in particular it's important that it was a review that happened alongside multiple other reviews and that different aspects of the reviews were published in different ways. In addition, we had 2 full HICWA inspections. Inspectors came for 5 days, 5 inspectors on both of those occasions since the operational review was undertaken. So I don't think it's fair to say that there is, while it continues to be a matter of regret that this report hasn't been published, I think there's no question but that the amount of information in the public domain about Oberstein operations that both the board and management have put into the public domain and has been in the public domain through other processes is significantly more than in the lifetime, certainly of my time on the board, but certainly in terms of the organisation as a whole. So transparency has been a focus, and I think part of the issue, I would also say in relation to publishing the recommendations, was to strike the most appropriate balance within our control, within our power, within what we felt was prudent, to put the recommendations in the public domain, but to do that with a narrative that responded to them. That was considered to be the safest and less risky approach in light of the public interest, in light of our need to focus on improvements and going forward, and in light of the significant work that had been done and put into the report. So there are my initial responses.
Well, thank you, Professor. And my only view of what you've put before the committee is, in my experience, it's often the quality of the instruction that determines the advices that are received back from in terms of legal advices. And it's often a very confusing aspect of when you're trying to determine what is the best approach to take. So you know, the quality of the instruction to the law firm or whomever you used most likely would have coloured the response that they provide you. And that's why I find it difficult to understand, with the available information, how Professors Hardwick and Goldson were not provided with the opportunity to be informed. As they've clearly indicated, they are not aware as to what is offensive within their report to you. Therefore, they could not offer to redact certain sections, which could then not go before the law firm that you hired or law firms that you hired to provide you with legal advices, which in turn coloured your decision not to publish. So I'm sure that you're all professionals and experienced, and I'm sure there are all sorts of different individuals within the board and within the management structure who would have expressed a viewpoint. But it still doesn't appear to me like one of the first things I would have done as a former member of other boards of management would have been to ask the authors of the report to come before the board and have a discussion about it. That didn't happen. And thus, they weren't aware as to what was offensive within the report as they clearly articulated this morning. And therefore, you as a board couldn't be informed by their viewpoint as to what could or could not be redacted and then later published subject to legal advice. So I cannot help but feel that the board has been very robust in how they've approached this, but perhaps you've either omitted something from your unintentionally or otherwise, something from your contribution this morning, or didn't think of it. And I just want to understand the lengths to which the board has gone to actually, as you rightly point out, produce value for money by publishing the report. You know, I'm not for a moment suggesting that there's some malevolent plan going on here. I don't think that that's the case at all. But I want to try and understand the lengths to which you went to publish this report, because I don't think it's immediately clear to all of us. So perhaps you'd like to respond to that, and then I'll invite Deputy Rabbitte to make a contribution.
So in our response to, and I think there's a couple of things there, because I think one of the concerns that arises when you look at this is that there was a gap in the fulfilment of the terms of reference with respect to the feedback visit, which, according to the terms of reference, was due to happen prior to the report being finalised, and was very clearly about the process of engagement with staff. This was, we did not seek out a root and branch review of Oireachtas at that time. What was sought was the expertise and insight from a different perspective of what was happening on the ground, with a view to creating a dialogue that would enable changes to be implemented. It was sought to be sort of unlocking of sorts of hearts and minds around these issues. It was not to commission, nor could it have been possible to do in the timescale, the kind of root and branch review that maybe should have been commissioned, but it certainly was not what this was intended to be. It was very much intended to be a process that enabled staff to move forward. And I think one of the things that it's also important to flag is that throughout this process, and the extraordinary amount of time that's been spent on it, both by me as chair and by the board as a whole, in early days in responding to the initial drafts of the report, focus was on factual accuracy checking. There was extraordinary attention paid in detail to concerns that arose from the report at that time, and they were flagged very early on to the reviewers in detailed form. It was also flagged very early on that because of the nature of the report, the way in which the report was written, not the substantive or not the critical nature of a report, the nature and the tone and the implication of what was being said, that flagged to us that there were legal matters that would require review, particularly in the context of Irish constitutional law and the Fair Procedures Law that has been elaborated by the courts in very recent times. So it was that broader context, I suppose, broader responsibility that the board had responsibility for, that whatever the reviewers could do in response would always be limited. And for me, the key issue was that the board did its job in ensuring that that was taken care of adequately and prudently. But I had, at every stage, flagged, first of all, that legal review would be necessary as a prudent step, and that the nature and timing of any publication was a matter for the board in light of these broader legal responsibilities. And in particular, not just under the Act, but under broader Irish law. So those matters were brought to the attention of the reviewers, and I was very clear about that. And so, it's really the, I suppose, distinction between a process of factual accuracy and what that can yield, and a more substantive process, which is essential to ensure that fair procedures are followed, and the review of that was the specific interest of the board subsequently.
Deputy Rabbitte.
Thank you, Chair, and thank you, Board, for coming before us today. I suppose the whole idea about the review for me, from my point of view as sitting here on the Children's Committee, was that this was the safety net for the Oireachtas Committee, that there was independent external assessors coming in to do a review within Oireachtas. And as you had quite said, this is your fourth time to come before us, Ursula. And it was set in the whole context that 2016 we had it was in the media continuously. We had a particular incident. We had Gardaí. It was in the front pages of the papers for week in, week out, and it was like, so it was at a stage where I felt myself personally life could be lost. That's how dangerous I felt it was. So when we heard and when we got the comfort that there was an external group going to review it, that brought some calm, that brought some comfort that we as an Oireachtas Committee were actually doing our job. And that was part of the dialogue over and back between yourself and also the operational manager on campus. It also was part of the dialogue we had with the Minister. But at nowhere along the line did I, as spokesperson for children on this side of the House, think I wouldn't have the whole document, because that was what it was all about, was in having the whole document, whether in a redacted version or whatever version. But having the recommendations without having the other part does not make sense whatsoever to me. And now, you talked about it was more about our hearts and minds. To me, it was about a root and branch as far as I was concerned, Ursula. That's what I wanted within Oberstown. That's what I needed to know. And I agree, there was a lot of reports and reviews taking place. One was in relation to the buildings. I know you had an awful lot of staffing issues. There was a lot going on. But my core plan and my core issue here is the protection of the children. And when you have 90-something odd recommendations, and I not knowing what policy is part of the pillars of the foundation of it, whether it be whatever part of law, we need to know where we can actually steer it into. So I feel we're working in a vacuum. I don't take on board the fact that time ran out before a final reversion could have been produced. I don't accept that, because I do think the fact that we would have had the two gentlemen before us today, I always think there was a meeting of minds there to actually, from both parties, to have it produced somewhere along the line. Having finished my statement, what I would like to know is, have the Board of Directors in Oberstown, have ye liability insurance? Have you liability as a board, and what does that cost? Because surely somewhere along the line, this is me just looking in here, there's only two named within the whole report, but I feel that there is complete and utter fear from the board in relation to the production of it, and that's why I'm asking, because anybody who is set on a board of directors would have ensured that there would be an insurance there to protect them. You have referenced HICWA as we have moved forward. While we have had the recommendations, we've made numerous progress steps. So I have the HICWA report here in front of me, which relates to the last 5 days with 5 inspectors. And I'll be quite honest with you, I can't find any comfort reading in it. While it might have improved, I'm still referencing the fact, and this is in page, wait till I tell you now, I have a number of them here. One is in relation to external parties to what makes up a board not attending meetings. And I talk about TUSLA not attending meetings, and it's actually in the report had not attended numbers of months of meetings at it. And you just bear with me now. Page 30. Why is it not required for TUSLA responsible to be present at all board meetings? So if I go to page 30 of the report from the HICWA, it says it was... In addition, the chairperson of the Board of Management told inspectors that there was no TUSLA representative in attendance at board meetings for a number of months, and the absence of the representatives from TUSLA directly impacted on the board's ability to prioritise and address their interagency matters. So, that is a huge factor that feeds into it. If we're talking about making decisions to move forward, on page 26 and page 27 of the HICWA report, and I know that's not what we're here to discuss, but it actually is very, very relevant when you're taking the recommendations in context if we're saying we're moving forward. Why and how was a child left in separation for 12 days? Why was physical intervention used in 10 incidents? And what kind of physical intervention? I'm only giving a backdrop, but we're actually like mushrooms here at the moment. We don't have the report. We need the report. It needs to be produced to us. There is nowhere along the line has the Minister or Oberstown given us any comfort that what was actually produced is actually working and those key recommendations are being followed through. That is where I'm coming from, and I'd like you to respond to what I've said.
Thank you, Deputy.
Okay, there are a number of matters, and I'll attempt to respond to them all, and please pick up if I don't. In relation to the TUSLA nominee, I brought to the attention of the department that the TUSLA nominee was intending, I believe, to step down due to other responsibilities, and there was a time lag clearly in the nomination of that replacement. I brought that to the attention of the Minister's department and repeatedly, and there were obviously we now have the TUSLA nominee on the board in full attendance. These matters arise from time to time as board membership changes, as gaps arise. I always very quickly bring to the attention of the department that the vital nature, particularly of of the department nominees. I could only do so much to do that, but I stand over what I reported to HICWA in the consultation with them as part of their process. It is and was a gap at the time, and that has now been rectified. I mean, I think in relation to the named individuals and the matter of insurance, what we are endeavouring to do all of the time is not to deal with risk at the brink, but actually to take the proactive measures that will prevent us being in that situation in the first place. I think what's really important, while there's been a reference here this morning to 2 named individuals, the legal risks arise in relation to identifiable individuals and not just named individuals, and the nature of the implications that are expressed in the report arise in that context. It's a much wider issue than named individuals, and that's an Irish legal concept that is very pressing in this instance. I mean, in the context of the vacuum, I completely understand your concern, and I really appreciate your long commitment, and we've engaged on these issues a number of times as I've been before the committee and elsewhere. You were in Oireachtas at the time, and I appreciate also you levelling with us on the gravity of what we faced. We were utterly aware of the gravity of what we faced at that time, utterly. And throughout that time, have no Pollyanna view about how things are on the floor of Oireachtas. I think it's really unhelpful to suggest that there was, and this is part of the difficulty, frankly, with where we are, to suggest that there is a lack of understanding of the true nature of the problems, of what needs to be done to unroot and unseat deep-seated practices that have built up for years. We are utterly aware and worked non-stop on these issues. I mean, I have daily contact with the campus. We have routine meetings, but in between, there is an endless, to my estimation, at least 2 days a week is spent on me, and it's simply not. It's not true to suggest that either the board or our management do not have full understanding and oversight over what is going on the ground. And so I'm not suggesting for a second that, notwithstanding the improvements, that we do not have a long way to go. We absolutely do, but that is very clear. I think you're right in the context of separation. This has been a really intractable problem, and Deputy Sherlock, we engaged on this last year. We have put an entire new policy and framework in place in relation to separation, but we've actually focused much more on the way in which it's recorded. We have an entirely new data collection system to manage that, and that is prompting a much greater level of detailed oversight, accountability and approval, including daily monitoring by the Director. And that is what has driven down the practice of separation dramatically, 50% each in 2017 and 2018. The board has been really clear and has issued a statement on the use of restrictive practices, on the unacceptable nature of those practices and how we need to take various steps to ensure the policy is right, but also implementation. And it's simply not true to suggest that we are satisfied with good policy. Professor Hardwick mentioned in the earlier session that we had good policies. I actually don't agree. We didn't have good policies. We've done a whole raft of work to put our policies on a firm, solid footing, and we're about to develop and improve an entire new policy framework that will set this up for the future. The extent of the work, both on policy and implementation of policy, is relentless. But we should not be under any illusions about the complexity of that work or of the demanding nature of it. And it wouldn't, any of it, be possible without bringing with us all of the staff on campus, both new and old, who've been there for years, who day to day do this work. And so the key issue in the context of the broader concerns about the report was its support and development. It had to enable us to move forward. I accept your interest in it was perhaps slightly different. You did want this root and branch and wanted that comfort. I completely accept that. And we need clearly to work better to make sure that you are better informed and feel that you have the assurances that you need.
But see, I don't need the reassurances. What I need to know is that the children that go to Oireachtas actually are treated correctly, because the HICWA reports that are coming out to me year on, do not give me that comfort, Ursula. And it doesn't give me any reassurances whatsoever. The fact of the matter is that I feel wholeheartedly that there's a complete and utter cover-up taking place here. And I feel it has gone on for the last number of years. And that was the only reason that I would have agreed 2 years ago to this review, the fact that there was going to be an independent involvement. Answer my question, please, about Board of Members' insurance.
I mean, it's not something we would have the same insurance as any public body. It's not something that I would be familiar with.
So do the Board of Members have insurance, yes or no?
I understand that we do, but I'm not, I would need to clarify that. I'm not sure.
Thank you, Chair.
Thank you very much. Deputy Sherlock.
Thank you very much. This is a political domain, it's not a legal domain. And again, to reiterate the points made previously, we do not have sight of the report, but we do have sight of the recommendations, and we take in good faith the statements that are made in respect of the implementation of those recommendations. What we find hard, and what I find hard to reconcile in my own mind, is the non-publication of the report. Now, I've listened very carefully to Professor Kilkelly here today in respect of the constitutional element in terms of implicating people in the report. And I appreciate that dynamic, I really do. Because while the professors state that nobody specifically was identified, that the language of the report could deem to identify individuals. Can I ask then, in light of what you've said, what was the exact nature of the independent advice that you gave, number one? And that was given to you. What was the nature of the independent advice? Be more specific about that, please. And what were the nature of the interactions with the Minister or her officials in respect of that independent advice? Because when the Minister came to us previously, she stated, "I've been advised by the Board that its decision not to publish the report of the operational review was not one that it either expected or wanted to make. It resulted from a lengthy, careful and extensive process of consideration which weighed up, in light of the independent legal advice, the legal risks associated with publication." Now, we in this domain are in the political domain, and we perceive that the non-publication of the report could arguably, be perceived to be covering up or protecting either, practice, culture, or individuals. And we need some reassurances from you that, that your independent legal advice is robust, and we need some greater articulation of what you mean by the implications of that advice.
So the legal advice, and I know there have been different reasons set out for non-publication. The Board has been, for its part, entirely clear and consistent about what its concerns were. The other matters which have been raised were considerations, I believe, that the Minister took into account, and that is her prerogative as Minister to have supplementary or additional reasons why she had those concerns. In the context of the report, the legal advice pointed to an absence of an opportunity to identifiable individuals to inform the findings of the review.
Okay,
The fact
can I ask you just to hold it there? In light of that very statement, was an opportunity given to those individuals, or were discussions held with those individuals with a view to interacting with the two eminent experts in respect of the content, if you will, and the language of the report?
So there were opportunities given by the reviewers to the Director and myself with regard to factual accuracy checking.
That's not what you see.
No, I'm being very specific.
Ursula,
I'm being very
Ursula,
specific.
please, Chairman. You see, there is a tendency in this House sometimes to go after people and after witnesses, and we're not. The dynamic of this committee has been very patient about this issue, and we seek to ensure that people's bona fides are respected. So that's why we need very clear and succinct and simple language. And I think my question was very simple, Professor Kilkelly, and if you could please, what I want to know is whether or not the individuals who might be implicated by dint of the language of the report, were they given an opportunity to interact with the eminent professors in respect of, the content or the implications of the language used in the report? Yes or no?
I'm endeavouring. I think the answer is yes, but it is one with qualification, because the key issue here related to when that process took place. That multiple opportunities were taken, multiple issues were raised with the reviewers throughout that deliberative process, but that all happened at when the report had been produced.
Okay, so.
And there's a very specific issue here with regard to ensuring that findings are informed by those affected by them.
Okay, so can I ask then, right, because you mentioned the report is the property, I think was the word you used.
That's what would normally be.
Well, okay, I'm just quoting back to you, correct me if I'm wrong, that the report is the property of those who commissioned the report. On that basis, who owns the report? Who owns the report?
Well, it's my understanding the board owns the report.
Okay, so the board owns the report. If the board owns the report, and notwithstanding these issues of timing, and again, notwithstanding the fact that this committee has demanded the publication of the report and we've had interactions with the Minister, is there now still scope and time, on the basis of the evidence that you've heard from Professors Goldson and Hardwick in respect of their willingness to engage at all levels and with all stakeholders, to go over that report again and to work through the content, if you will, of the report, such that if it is deemed that there are adverse findings or implications against certain individuals, that could be worked through? Because from my perspective, in seeking to address the issues around the recommendations that you've published, is that even if you fulfil those recommendations that you published in July 2017, we still have the sword of Damocles of this report hanging over us. And as I've said at the outset, we are in the political domain here, not the legal domain. And as has been the case with reports which are perceived to be suppressed in the past, they always get published, one way or another. They always get published.
Your last question, if you want to answer that.
So my last question is that I perceive, and I say this respectfully, Professor Kilkelly, that there is a defensiveness here on the part of the board, which I did not perceive the same defensiveness on the part of, and this is perception as reality in the political domain, okay? We didn't perceive the same defensiveness on the part of Goldson and Hardwick, and I think that both sides need to sit down and go through this report again and find some common ground, whether that's brokered by the Minister or whoever. But one way or another, this report will have to be published, because I think the public interest absolutely demands it.
I think, as I said earlier on, Deputy Sherlock, one of the challenges here is that the law requires, as we now understand it, that this engagement and response is essential to take place before findings are reached. And what the process you're talking about now is and it was clear in the deliberations that findings and recommendations did not change, notwithstanding any corrections.
But there's a contradiction there, Chairman, is there not? Because if you're saying that findings have been reached, and you're going to and you've already started Have you not accepted the report on the basis that you're fulfilling the recommendations of that same report, and ergo you've accepted the findings of the report, you've accepted the content of the report?
What we are endeavouring to do is to take as much as possible from what is positive about this process and use it to maximum benefit.
So the report then arguably is not a final report?
Well, no, it has been made very clear to us that this is the final report by the reviewers.
If we have time, we can have another round, Deputy Sherlock, with respect.
Thank you, Chair.
Thank you. Okay. Deputy Chambers, please. Then
Yeah.
I will ask for Deputy Neville and Deputy Mitchell and Deputy Daly.
Thank you, Chair. Thank you, Professor Kilkelly and Ms Woodfull and Mr O'Leary for coming before us. And it is just to try and get facts and information. It's not about trying to undermine. And I'm conscious as well in terms of the impact on the reputation of the two professors, Professor Goldson and Hardwick, that your opening comments are not overly complimentary. But just to say that our interactions with the two professors before this was very positive, and certainly I found their evidence to the committee very persuasive. Just in terms of the constitutional law aspects, Professor, that is always, of course, balanced with the public interest. And you are asking our committee to just accept that you were advised that the tone or the implication of the report was such that it prevented you from publishing it, and so we just need to move on. I don't think we're accepting of that. Obviously, I can only speak for myself, but certainly in terms of looking after the interests of children at the facility, it's my belief that the public interest is best served with publishing the report, and I've heard nothing so far that would convince me otherwise. In terms of the process, just I suppose the terms of reference, the aims of the review was to evaluate practice and policy in line with international standards. We don't know if that was done because we don't have the report. To identify obstacles or barriers to achieving greater implementation of international standards. Again, we don't know if that was done because we don't have the report. And finally, to make recommendations to ensure greater and more successful implementation of these standards. We have the recommendations but no context, so we have kind of half of that one. So the aim of the review has not been met, but obviously the cost has been incurred on the state. In terms of the process that you referred to, the terms of reference, can I ask you, Professor, was the process followed? You've referred to this meeting that should have happened before the terms of reference were finalised, but then you did say that a summary was provided to you before it was finalised. So are you saying that the terms of reference, that the process in the terms of reference was not followed, the 5 points you've identified in your opening statement?
That's correct. The terms of reference provided for a sequence of events, and in that sequence, quite deliberately, the feedback session was to take place prior to the report being finalised. And in my view, if the sequence had been adhered to, we might not be in this position. Because as we heard earlier on, there is no one afraid of criticism here. We are subject to criticism and scrutiny routinely. We do not, absolutely do not shirk that. We wouldn't be here, frankly, if we did. So we are very open to that as an objective process, and it would have been helpful. But for whatever reason, the reviewers were and I accept this as our bona fides, they were keen to finalise the report prior to an engagement session with staff and the board. In hindsight, I think that we should have insisted that that feedback session took place in the informal way in which it was intended. This was not intended to be a launch of the report, if you like. It was intended to be, here's what we found, how does that sit, and how does this all, as was indicated earlier on. That was the indicative process that was set out.
So are you saying, sorry, President, that the presenting of findings and recommendations to staff, management and the board, that didn't happen at all?
No.
And was there engagement then with staff members and with the board throughout the process to get feedback on how things were going? Because obviously there was a first draft presented. You say there were factual inaccuracies. Were they addressed before the second draft was presented?
I undertook to provide feedback of that nature to the reviewers, and it was at their discretion to take into account, and you heard by their admission that they took it into account. I think there are probably some differences about that in terms of interpretation, the extent to which those points were made, but it was within their gift to decide how matters we raised and I raised were addressed with them.
Just, you had said to Deputy Sherlock just previously that there was an opportunity given to those implicated in the report to actually interact with the reviewers and give feedback. Is that not satisfying point 4 in the process before finalising the report?
No.
If there is that interaction.
No, I mean, there are two things. One was the limited nature, and that's why I made that point, probably pedantically, about factual accuracies. It was a limited form of response, it's certainly in a legal context in terms of providing the sort of safeguards that are necessary before a report of this nature would be published. It is vital that is a substantive process that takes place before findings are reached, and by its very nature, when the report was concluded, prior to that feedback session.
And did you raise these concerns with the reviewers, that we don't want you to finalise the report until we have this feedback session in the format that you wanted?
Well, yes, there was some dialogue at the time that the sequence of that was and should be as set out in the terms of reference. Their preference, and I understand why they wanted it that way, but their preference was to finalise the report first. I, frankly, really, should in hindsight have insisted that things happen differently, because that would have honoured better the nature of the process. But as you said, we are where we are. I mean, I think in the context, and you make the very valid point about the balance with the public interest, we totally accept that, and that is why we have grappled with this issue. We've dealt with it now in 22 meetings of the board. No one more than us wants to see this resolved. But we got not just our own independent legal advice, there was further separate legal advice and the review of the Attorney-General on the matter, which favoured or decided and determined the balance struck in the way that we see today. So that was not just solely the advice provided to the board, but other sets of advice also.
If the focus is that this feedback session didn't occur, I mean, do you believe that feedback session would have substantially changed the findings in the report?
But it was intended to be what the report was about, the process of engagement.
Yes, but I suppose the point I'm making
I
is
think
that,
absolutely.
I mean, I suppose at the outset, I mean, was there an expectation that the report would somehow be complementary of the facility?
Absolutely. I really don't think that's and I mentioned at the beginning that the nature and the number of reports that were ongoing, the reviews were ongoing at the time. There was at the time, as we would say, no lack of information about what was wrong with Oireachtas and how it needed to be fixed. I think that's fair to say. So it was absolutely not, but it was intended to try and get to the heart of some of the issues that we were struggling with, not in a substantive way.
Okay.
Not in a way that dealt with the details per se, but actually trying, if you recall at the time, there was discussion about the use of PPEs, of riot gear. There was discussion about whether Oireachtas was the right place as a effectively high secure facility for young offenders, older offenders, more serious offenders, remand, etc. These were debates, just to say, these were important debates ongoing at the time, and this was designed to get at those issues.
I think the intention was good. I mean, to be fair to the two professors, they would dispute your interpretation of how the process worked. They will say that they engaged all the way through, that they were very open, willing to change, willing to interact, very much welcome feedback, wanted to engage with staff and with the board. So they would take a different interpretation of what and they've obviously presented that evidence to our committee here. If the only issue is that the feedback session didn't happen before finalising the report, is it your understanding that the reviewers were willing to address concerns with the final report, to make some changes? Did you interact as to how, when you realised this was an issue for you and your board, and for those that are implicated, allegedly implicated, because we don't really know what the nature of that is, did you discuss with the reviewers how to fix this? How do we go about publishing this report? Can we have the review session now and see, does it materially impact on the findings, and could we alter the tone in some way? Did you have that conversation, or did you just make the decision that we can't proceed because the process wasn't followed in absolute order?
I mean, I think it's fair to say that we had the extensive engagement. In particular, I personally did, and I think it's fair to say we'd reached somewhat of an impasse as to how we were going to move forward. And certainly, it was made very clear that the report was final, that there were no substantial changes happened throughout that process, despite some changes. certainly that was not a matter that we would be able to address through further dialogue, unfortunately. And this, was absolutely not where we wanted to find ourselves. But it was the reality of the risk we were managing at that time.
What happened at the end of February 2017 when you had the final report, up until March 2017, then when you decided to seek independent legal advice? What happened in that kind of month period? Who had sight of the report? Who flagged the legal issues? Who saw this and thought, we've got an issue here that we need to get legal advice? Did you decide yourself? Did the board collectively make that call? Did the
board made that decision at its meeting, and the time lag is simply reflective of our meeting cycle.
So what in the report then? I mean, was it a case that the staff implicated had sight of the report, came to the board to raise concerns, and at that point then you decided legal advice was necessary, or what prompted seeking that legal advice?
The board, having had sight of the report, was concerned at the issues that it raised, as I've outlined already. So it was a collective board decision to address it in this way.
And in terms of last question, in terms of the legal advice, I suppose we don't really know the extent of what the legal advice was, and it hasn't been published. I don't see any reason why it shouldn't be published. It's not Attorney General's advice. You had independent legal advice to your board. Will you publish that?
Well, certainly it is a matter that the board has considered. The reviewers have sought the legal advice, and the view of the board was that it was confidential to the board. There are matters pertaining to the substance of the report in the legal advice.
Summary. What about a summary?
I can certainly look at it if it would be helpful.
It would.
I can bring it back to the board for their consideration.
I'm sure that the providers of the legal advice could provide you with a summary, which could be provided to both this committee and to the authors of the report. That would be beneficial.
I think it would be absolutely necessary. There's nothing, whatever about the Attorney General's advice not being published, there is obviously precedence for that, but there's nothing to prevent. You're asking us to take a leap of faith and trust that the advice you gave, that we would have the same interpretation. I see no good reason why that advice cannot be published, even in redacted form, if it specifically references parts of the report which you wish to not publish.
And it's exceedingly difficult for us to take that leap.
I understand that completely. I do understand the concerns the committee is expressing. And
Thank you. Deputy Neville, please.
Yeah, thank you for coming in. Just so I'm clear here, I was just listening to the questions there from Deputy Chambers. What you're saying is that in the sequence of events, number 4, presenting findings and recommendations to staff management of the Board of Oireachtas, okay? You're telling me that there was a reversal of 4 and 5. Is that correct?
that's correct.
In bottom line. So because that you feel then the proper process has not been followed. So that if they were reversed, that the findings would have influenced the final report, whereas now we have a final report and the new findings are...
I think that contributed to the challenge, yes.
At any stage, at what stage did your board make a decision to seek legal advice?
At the stage that was outlined earlier.
Okay. Was there any discussions around legal advice at any part during this process? Because you were seeing, obviously, there was discussions taking place, there was an over and back taking place, and given your experience that there may be implications in relation to whatever arising, was there ever any discussions around legal advice before the decision was taken to get legal advice?
My memory is that there was. Certainly it was a consideration that I had flagged very early on, that it was a concern that certainly that legal review would be important.
And why wasn't that taken before the final report was generated? That it would in itself have an influence in the final report? Because as you said yourself, you wanted to find a solution, which we all want to find, to make sure that everything's open and transparent. Why wasn't that flagged, or why wasn't that decision made before the final report was done? That it would actually feed into the final report?
I suppose that, as the risks emerge, you deal with them, and I don't think it was flagged sufficiently as an issue at the time you're describing. So I'm not sure why it appeared as an issue when it did, and that was when legal advice was sought.
So at no stage before the final report, the board went, you know what, there's something that we may have to put this towards legal advice.
No, we did.
You sat down and discussed it, and the board made a decision that at that stage, before the final draft was, or before the final report was done, that no legal advice would be sought until
No,
after.
there wasn't a decision ruling out legal advice, no. What I'm saying was that I had brought to the reviewer's attention that legal review would probably be necessary.
Okay, but is there any...
And there would have been briefing on that matter in the board.
Okay, but what I'm trying to understand is the rationale as to why that legal advice wasn't sought before the final report was put together. Why wasn't legal advice sought before that? Because using rationale or using... You would believe that that legal advice would feed in to the final report. And I'm just asking why the board didn't seek legal advice before the final report was generated.
But the advice was on publication of the report, and so it only came to be considered
So
in that
decision,
specific
okay,
context.
so you made your decision on a process matter, that you were saying that the process was that...
And every effort was being made to resolve the matter satisfactorily. Nobody wanted to go to the expense, never mind the extraordinary efforts to resolve the matter in that way, unless it was absolutely necessary.
And given the fact that you were flagging legal advice before the final draft was done or before the final report was done, that you knew that this was coming down the track, did you not feel it may have been prudent to seek legal advice before it?
I think in hindsight it might have been prudent. I think we can only do the best in the time that we have. I don't think, and we can continue to learn from processes like this. I wouldn't have wanted to go for legal review unless it was absolutely essential, and it became critical at a point of the insistence of publication.
And
that's where it became a real issue.
Was there ever any discussion then that once, obviously when you had made the decision to seek legal advice after the final report was done, was there any discussions in how to put into practice of what, if the legal advice was contrary to what was in the report, on how that would be resolved? Was there ever any discussion around that before the final report was done? Was there ever any forward thinking or any forward discussion done on that once I would produce a report, I go for legal advice, and that legal advice is contrary to what's in the report? Was there ever any discussion before the report was printed to say, well, what are we going to do next after that?
We dealt with it in sequence. So when,
sure, I understand that, but was there any discussions around, it's called, like risk management or risk planning, that if this may happen, do we have a fallback plan, and was there any discussions around that?
Because I think we were very focused on trying to find a positive outcome, trying to see what the best possible way forward was, and also maximising the transparency around the report itself, which is why we chose, unhelpfully as it may seem, to publish the recommendations with a board response and not the report itself. But the legal advice was around the specific matter of publication. And we did consider and also sought input on whether a redacted form would satisfy, would strike that balance effectively. And again, the advice was that it wouldn't, and it would be very difficult to produce anything of substance, anything of meaning, and that was subsequently or separately considered. Okay, so taking on that point, as you mentioned about redacted, when you looked at the report and you made the decision to publish all the recommendations, you're telling me that the legal advice was that right across the board in relation to those recommendations, none of the rationale behind those recommendations and how they were arrived at could be produced. Did the board or your legal advice actually segment the report into each recommendation and go, well, we can print a rationale behind recommendation 2 or recommendation 5, but we can't do recommendation 6? Was it segmented into that specifics when you were seeking the legal advice? Because like I'm saying, just given the committee, we're completely in the dark. I know, and unfortunately the report isn't structured in a way that would enable that to happen, and we did have a look at that as to whether there were certain parts of it. And I don't want to go into the detail of the report, but I do think there are some helpful examples that might illustrate that, but I'm reluctant in the context of where we are to go into the detail of that.
Okay. All right. Thank you. Thank you, Chairman. Thank you for your time.
Deputy Neville. Deputy Mitchell, please.
Thanks, Professor, for your presentation. First of all, I just want to say I think the whole handling of this is complete and utter mess. We had the two Professor Zimmerers earlier. They have submitted this committee with tons of references of, the procedures that they went through. So I'm just confused here, because originally we were given 4 different reasons why this report wasn't to be published, right? So I want you to maybe explain a bit of that. Then we heard there was legal advice, right? Legal advice that wasn't shared with the two professors who wrote the report. And now you're coming in here, and maybe I'm wrong, Professor, but are you suggesting that another reason why the report wasn't published was because the feedback didn't take place? Because I'm confused here, because I'm hearing about feedback, I'm hearing about 4 different reasons. So you need to be specific here. Why wasn't this report published? We've had so many different answers, and to be honest with you, it's not acceptable. In my opinion, and other members here, I believe that you are obstructing this committee in its work. And I think that's really serious. So I think you really need to come back and tell us up front and centre why wasn't it? Is it uncomfortable reading? Is that the reason why this report wasn't published?
First of all, that is absolutely not the case. We have read multiple reports about Oireachtas that are uncomfortable reading. We have read multiple and commissioned multiple reports that are critical, highly critical. So that is absolutely not the reason. I want to absolutely categorically state that. What this is about is ultimately, and I think to your point about the 4 reasons, the board has only ever reported 1 reason. The other reasons are for the Minister to articulate, and I believe she has articulated those reasons, both to reviewers and publicly. The board has only ever and has consistently said that its concern is with fair procedures.
So can you
and
explain?
that those safeguards, and this is the relationship with, and I'm only trying to explain to help the committee understand why we got to where we are. Not in a critical way, but to explain that if the feedback session had taken place, which would have provided the opportunity to engage and to reflect and to allow the reviewers to understand the context and related matters.
So we're nailed to now. Fair procedures. The reason why the report isn't being published is because the feedback didn't take place.
No, my point is that the feedback session would have mitigated that concern on reflection.
What other fair procedures? What else was there?
No, I'm saying that the feedback session would have provided an opportunity for those fair procedures to have been, the requirements in Irish law around fair procedures to have been met prior to the report being finalised. That was the sequence that was set out in the terms of reference, and that was the sequence that would have avoided where we now are, where the risk of the legal risk associated with the breach of fair procedures is problematic for publication only. And so the board has been very consistently clear about that issue. And I think to the point that was made earlier on, and I know that the references being made as to the reasons why the report should now be published, the idea that, for example, in some way that it's offensive or that lessons will not be learned. And I repeat that this is a constant process of improvement, of learning from reviews, multiple reviews, HICWA inspectors' reports, and so on. The process of getting behind the problems and understanding them and remedying them is ongoing on a daily basis. So I don't think it's fair to suggest that a report that was completed at over 2.25 years ago is our only source of wisdom, frankly, on these issues. We are really open to expertise and insights from anywhere, but the work has to be done by those in Oireachtas. And that
if I can come back into that about what you're saying there, everybody in this room acknowledges 2016 was a difficult year for Oireachtas. There's no doubt about that, right? But we need accountability. And this is what it's about. It's about accountability and transparency, right? Mm-hmm. Accountability requires the publication of the report so we can see why these recommendations are in place. You would agree with that?
I understand.
Okay.
Completely understand that.
So we know good things have taken place in Oireachtas. We know there's been HICWA reports where there's been improvements, but we also know from the latest HICWA report that a lot more has to be done. Nobody is disputing that. But we need to see this report in its capacity so we can see where these recommendations came about. It's simple. It's not rocket science here. But I just want to touch on something else with you. Do you believe there was a breach of contract by the authors of the report?
I'm not prepared to. I really don't think it's helpful to engage.
No, but I think it's a question because my understanding, they've been paid in full.
Yeah.
So why would you pay somebody for a report that you're not happy with.
Because we
Come
respect-
here, if a workman came into my house and painted my ceilings and didn't do a good job, you're not going to pay him, right? So these professors done a job which was acceptable and which was right with the recommendations, so they received payment, but yet the board isn't publishing the report.
Personally, I'm not in the business of arguing out over contracts when it comes to payment for work done. There was lengthy and detailed work done. I think it was the right thing to do to pay the reviewers for their work, notwithstanding related concerns and issues. This is not a concern, and I really feel in treating people properly that was an element of dealing fairly with them on that matter. And I think to your point about transparency, Oberstown rightly is one of the most scrutinised organisations and facilities in the country, and rightly so. It's absolutely vital. And as I mentioned, since we've come into place, we have overseen significant increases in the amount of information in the public domain about Oberstown. Yourselves, committees have been out and are invited out routinely. Anyone who wants to come out to see the campus in operation, to meet with staff, perhaps with young people. There have been multiple, 6 I think, other reports which have either been published or shared with the relevant stakeholders. All of the HICWA inspections, and HICWA, don't forget, had access to this report, were published in full. We had last year a full constitutional action which aired many of these issues. That is ultimate accountability in the High Court. We've produced annual reports. We have extensive data on our single separation process and other restrictive practices published. We have regular stakeholder meetings. There are multiple mechanisms used, statutory and otherwise, to ensure transparency to the maximum extent to what we do. I completely understand your frustration around the recommendations, but from our point of view, it had to be safe to place the full report in the public domain, and very regrettably, that was the stumbling block that we came across. And we had to just deal with the reality of the risk that was presented at that time in the way we did. I'm absolutely confident that if we did it again, it could be done differently. But there is no cover-up.
Is there a way around this? Are you close to this now? The report is not going to be published. Is there any going to be further meetings? Is there any arbitration or anything that can take place that this report can be made public?
I mean, it's clearly a matter of, I understand it's a matter of concern to the committee. You've spent a lot of time on this issue. I appreciate and respect your time. The board too, as I mentioned, has spent multiple hours and days of time on it. We are endeavouring to do that alongside everything else that this voluntary board is doing. It's a hugely onerous responsibility on everybody. But we will look, I will take back the comments and the feedback from the committee to the board. No, I'm not concluding. I'm just responding to the particular point about where we are and moving forward, to say that I will certainly continue to do that.
We will look at that.
If you request me to do that, I will absolutely do that. Yeah.
Deputy Daly, please.
Thanks, Chair. I suppose I haven't heard anything that convinces me of the board's decision not to publish. And I suppose I'll maybe start with that. And you made the point that the board, prior to its decision, evaluated these matters with exceptional care and diligence, and that the decision not to publish was taken at a meeting on the 22nd of May in 2017. Had all of the board members received and read the report prior to that decision?
All the board members were given an opportunity to read the report.
Had they received a copy of that report that they were allowed to read and take away?
No, they were given an opportunity to read the report in full.
And they were given that opportunity on the day of that meeting, isn't that right?
That's correct, yeah. I mean, there was also a subcommittee which took responsibility for dealing with the matter in much more detail on behalf of the board in light of the legal risks.
So who were the members of the subcommittee? And how many times did they meet?
I don't have that information to hand in terms of the meetings.
Who were the members?
The members of the subcommittee were Emer Woodfill, Diego Gallagher and Liam Walsh.
And they had the full copy of the report to read, presumably?
They had the report to
So
consume,
just
yeah.
in multiple correspondence and the information that turned up in FOI, we hear talk of the board's decision. But you've just confirmed that the membership of the board did not have a copy of the report which they could read in their own time at their own perusal prior to taking a decision not to publish, that they got sight of and were allowed to read through without taking a copy that report on the day of the meeting that the decision was made not to publish. Now, do you not think there's a little bit of a contradiction in calling that the board's decision not to publish?
The manner in which the report was handled was informed by the legal advice that we'd been received. The way in which the board handled the matter was also informed by legal advice. And that was our legal advice, that the risks were considerable. There was much more time than you're indicating given to members to read the report. And I made it very clear throughout that board members who wanted more time, who wanted time to consider it in more detail, would be given that opportunity.
Why weren't the board given a copy? Like, do you not trust them, or is there a problem with some of the membership, or why would the board not be given a copy?
I was advised that that was a prudent way to manage the matter.
By whom?
By legal advisors.
Legal advice, right, okay. Just looking at some of the correspondence in terms of FOI, and we know that the Department of Children were saying that you had concerns that the reviewers mightn't have been aware of some of the legal matters in progress which could have affected some of the narrative in the report. It's a matter that we discussed with the professors earlier. Is this a reference to legal proceedings around the damage to the campus in 2016?
No.
It's not about that. So what is it about?
There are multiple matters, both live, ongoing legal cases, litigation of a civil and a criminal nature, which impact on the decision to publish the report.
So you're saying that the legal matters to which you're referring, that none of those matters have been concluded in that time?
There is such an extent of legal matters ongoing that it's hard to give you a definitive answer. I can tell you that there are, in particular, that the criminal cases you're referencing are ongoing and live. They are not concluded in relation to the 29th of August 2016.
So the legal matters that you say the researchers mightn't have been aware of are multiple. How many?
Probably 15.
15 legal cases. And do they involve the young people or do they involve the staff? Are they both? And how many are civil and how many are criminal?
Probably half and half, but I don't have that definitive information in front of me. I don't think it would be fair
because
to,
I can tell you, I can imagine that the general public will be quite shocked to know not only do we have this scenario here now, but behind it we have at least 15 cases which have been ongoing now for multiple years, supposedly, all impacting on the situation in Oireachtas and no information given on it, it seems.
Much of this information is in the public domain in other fora. This is not confidential information.
Well, you haven't told me any of it, so could you give me some of those examples then? Because I specifically asked you what were the legal matters and you told me you couldn't talk about any of them because they were ongoing. So could you talk about the ones that you were referring to that you can talk about? If it's in the public domain, presumably you can.
You can't.
I would prefer,
But
I really would prefer not.
I really would prefer.
I understand that, but I mean, if you listen very carefully to what I read out at the beginning of every meeting, I'm very clear, and it's not me, Deputy. I'd love to hear the answer to the question.
Well, I let the fact speak for itself, to be honest, because I don't see why the report couldn't have been redacted. But I just want to move on to some of the issues around the excuse, and it smacks me of an excuse of non-publication, this idea of fair procedures and right to reply, and I don't understand what that means. And from having examined all the documents under FOI, it does seem to be a bit of an elastic sort of a thing there. We know, for example, you've said that, well, this is Irish law, and it's constitutional matters. But she took the decision not to publish prior to the Attorney General's input into this process. We know for a fact that the Attorney General's office were actually trying to deliver a pathway towards publication in November 2017. And what they said at the time, and as the chief guardian, I suppose, of the Constitution, better than whoever, no disrespect to them, but whoever the Board of Oberstown commissioned wouldn't be on the level of the Attorney General, shall we say, and that he said, and his whole caveat in this was about giving the staff a chance to respond to the concerns as a pathway to publication. So what was done? How many staff? We know from FOI that the director was given a chance to have an input into the process. How many other staff were given an input into that process?
On that specific issue, the board was entitled to make the decision that it made, informed by legal advice. People will not like it, but the board has that authority, having commissioned the report that was within its gift. So the process that happened subsequently clearly involved the Attorney General. That was with respect to the Minister's decision to publish or not the report. With regard to the issue of consultation, the view of the board was that it would realise, or at least partly, if not fully, realise the very legal risks that we were mitigating against to start circulating the report and asking for input and feedback. And in particular, I suppose the concern was that would also create a dynamic that would not even help us to resolve the matter, would exacerbate the situation.
You would accept that the Minister requested that staff would be given that opportunity, that she asked for the report to be published.
Yes, and it was at that time formally referred to the Director on behalf of both the Director's Office and Campus Management to undertake that consideration on behalf of that group.
So subsequent to receiving the input from the Attorney General, who was seeking to facilitate publication in the public interest, did you go back and get more legal advice based on the Attorney General's input as the guardian of the Constitution?
So it's my very clear understanding that the Attorney General expressed the same view on publication as the legal advice to the Board of Management.
Not to publish.
Yeah, absolutely.
Not to publish.
Absolutely. What the Attorney General said in the correspondence under FOI was that people who could possibly be identified in would be given, if you like, a right to reply or have their input initially.
But my understanding was that that was not with respect to general publication. That was with regard to specific access to the report by this committee,
well,
I believe.
That's certainly not my understanding of it. And if
but
I can,
that I believe is the case.
And just can I reinforce the point that Deputy Daly is making? Like, there's correspondence here through the FOI, and thank you, Chairman, where to yourself, and this is on the 13th of the 11th, right? So you've got your legal advice on the 13th of March. We're now in November of 2017, and it's from a principal officer who shall remain nameless, okay, to protect that person, from the Department of Children and Youth Affairs, where, and I quote, "The Department is of the view that the following are mechanisms to progress matters in order to ensure that the matters you have raised and are addressed." That's the independent legal advice. And one, they set out a set of proposals to you. A response to the authors of the report pointing out the existence of concerns about fair procedures and suggesting a further process of engagement with staff and management of Oireachtas in order to ensure that persons criticised in the report have been fairly heard, or in the alternative, a submission by the Board of Management of Oireachtas campus on behalf of those persons criticised in the report to be disclosed to HICWA and the Joint Oireachtas Committee along with the report itself. So in other words, and to reinforce what Deputy Daly is saying, I mean, we are very much of the view that everything was done to try and facilitate the board, either through further engagement with the authors of the report and through the legal mechanisms of the highest offices of the state to facilitate the publication. But yet, you refused on the basis of your own independent legal. I mean, it's
Okay.
beginning not to hold water, the
Yeah.
arguments that you're making
Thank you,
here.
Deputy
To
Sheriff.
be frank
Yeah,
about
yeah.
it.
Professor.
I mean, I think that it is my clear understanding that the attorney did reach the same view on non-publication as that ultimately the board decided, or the independent advice to the board had decided. That's my understanding. The board was dealing with this matter month by month, and had been at this point dealing with it extensively and exhaustively, as had I as chair. The suggestions and recommendations that were made to the board by the Minister's office were given consideration by the board, and ultimately the board's concern was twofold. One, that this would not be productive, would not yield the sort of outcome that we all wanted, and that is to resolve these difficulties, that we had reached a level of impasse that would not make this productive. And secondly, that in fact, the very risks we were trying to mitigate against would be realised through this process. That was our understanding of the issue.
I don't understand
you're
what that
fine.
means in English, basically.
Your
I'd like
your
it
last-
answered
your
in
last
English.
question, please, Deputy
Well, no, I'd
Daly.
like that question answered first
Yep.
before I do my last one.
But if
Because
it's-
first
if
of all, you said it was legal impediments, then you said it wouldn't be productive. What does that mean? And the risks?
That it wouldn't actually have produced a report that was legally safe, ultimately, that it was going to be so difficult to resolve.
But you confirmed to Deputy Sherlock that the letter and the points made by the department were not responded to. You didn't go back and check that legally. You had old legal advice. You didn't go and test what they asked you to do legally.
You decided not to go along with that suggestion.
Because the problem was that the board's understanding was that the risks were associated with publication, and what we were being asked to do was effectively to place the report in the public domain as part of that
Yeah, but
process.
you were being asked by the Department of Children to follow a set of steps which they had got legal advice prior to giving you, and you say you didn't do that based on legal advice, but you hadn't got any legal advice responding to their advice. It's
No, we
absolutely
haven't.
In
critical.
fairness,
No.
and to put it maybe on the record, because I think the time is similar, Deputy Daly. But the Board of Management of Overtown spent more than €19,000 between February of 17 and April of 18 on legal advice pertaining to the assessment of the operational review. So all of that money was expended in the provision of legal advices, but it doesn't appear from the
And
questions
even
that
with
you have
this-
been asking that any of it related to the correspondence with Tusa
No,
and the legal advice source.
Just
Chairman, can I just...
Department, excuse me.
I've put on the record what was written to yourself, Professor Kilkelly, in respect of the department. And the department, by any interpretation, objectively speaking, was seeking to suggest further engagement with the staff and management to ensure that persons criticised in the report had been fairly heard, okay? And, and that it was basically pointing to, notwithstanding the fact that a finding had been made, taking that into account, and you've stated that previously, but that there was still scope and room for further engagement before the publication of the report to further engage with the various stakeholders. And it seems what you're saying here is that in spite of that advice or those suggestions, that you still decided to proceed on the basis of your own independent legal advice.
I mean, at that point...
There was a pathway being sought for you, and you refused that pathway.
And I think there were two issues there. One, the board had made its decision. I suppose my question was whether we were being asked to revisit that decision. That wasn't clear to me. I mean, the other question is that the reviewers had made it clear that the report that we received from them in February was final. So that was made very clear, and I think it's clear from correspondence with the department as well.
Deputy Daly, to conclude, please.
This is crazy stuff. I mean, it really is. I mean, staff and management being given a right to reply, as it were, was the pathway put forward by the department to allow you to publish. And it seems to me, from the actions, and maybe you could correct me, that actually the director was the only person who was given some type of right to reply. Nobody else was sought. Now, the two professors have told us that the only people identified in the report are the director and yourself. They actually, in contradiction to what you said, don't believe that anybody else can be identified, that anybody else was identified as coming in for criticism or whatever as it is. So the only conclusion, there's only two possible conclusions I can draw based on that, having not seen report. Either the director was the only person criticised in that report and somehow or other threatened or whatever, because we heard about resignations, that if this comes out, I'm walking, or else the whole thing, to be honest with you, is a bit of a puff of smoke. It doesn't add up in any other way, because why didn't you give other people a right to reply? We know you gave the director from the correspondence, had a lot of replying. So is it the case that the director was the only person? And it's very pertinent, and I want you to, because I know the chair is telling me to answer the other point, which is what the other deputies have said, is do the board accept the recommendations, all the recommendations? Because if you, well, I suppose you can answer that, and I will follow up one on that one. But
I just want to put on record, under any other circumstances, I wouldn't allow that conversation to have taken place. But I came to the exactly same conclusion as Deputy Daly, and I think we all have. So,
yeah,
On the recommendations, you mean, Chair?
no, I mean as to the identity of individuals. And that brings me absolutely no pleasure in pointing that out, but I came to the
I have
exact
made
same.
it, I think I have already stated that the understanding and the concern around the risks related to identifiable individuals, not just named individuals.
yeah, but the professors have said nobody who's up for criticism can be identified by this report.
And that is their view, but I don't agree.
I think in fairness to Deputy Daly, and by all means ask another question if you wish, but I think the point is made, and I don't want to necessarily go down that particular rabbit hole, because, you know, the report hasn't been published on foot of legal advice, and we're now delving into it in a manner which I don't think is appropriate for this committee in the forum that we're in, for the very reasons that I outlined.
The only thing that's now, it is a
commencement.
matter of record, if you like, or a matter of,
No,
that's
I
not in
understand
dispute, that the director was given a right of reply. And we know that everybody asked, and the department asked, that anybody criticised in the report would be given a right of reply. And we know that the director was the only person given that reply. So either it was a threat maybe, and in light of your comments about previously to the department about resignations and all that kind of thing, either there was some manoeuvre there, or what, is there another reason? I don't know.
Could I answer some of these points before?
Yeah.
Sorry, no, actually, I'm going to allow Professor Kilkenny to respond, please.
Okay,
Professor Kilkenny.
So, first of all, on the point of in response to the department's correspondence or recommendation, a formal process took place at that point to refer the report to the director, who has not just the role of director, as you might expect, but actually has a statutory authority. So it is a substantive role in addition to being director and manager, if you like, of the campus. And the response from the director on that matter, on behalf of Oberstein, in addition to being on his own behalf, dealt with a range of issues which raised the concerns that we then brought to the attention of the department and ultimately the Attorney General, I presume. So to the point that the department made this recommendation and we refused to respond, that is simply not true. The process that was put in place was that it was referred to the Office of the Director for consideration, and then a further correspondence that came back on that, raising a range of concerns, were then referred on to the department. So it's not fair to say that we stood there either and did nothing or that we resisted. Actually, we endeavoured to try to respond to ensure that whatever mechanisms were available to us were used.
But the only objection the department had was about people who could be potentially identified for criticism having a right to reply. So you're saying that the director, in addition to the points of criticism about him, had all these other points. Were they about the other people who were?
No, these were all. They were largely about the fairness of and the extent to which safeguards had been met in the finalising of the report. And the crucial, again, the crucial point about that is that it is required that the opportunity be given prior to finalisation, not as a responsive
we heard that point,
mechanism.
I think,
But that, I think that's pretty crucial, because it explains the limited nature of the process.
My last point, and I think we've had some very clear evidence today, but accusing academics of flouting fair procedures, as the board have levelled against the 2 visiting professors, is an incredibly serious charge, which should only be put with evidence to back it up. I haven't seen any evidence in any way that would undermine the work done by these 2 professors. And my last point is tied into that. Do you support their recommendations? Because one of their recommendations was that the board would commission an independent review of senior management to make sure it was suitable to direct Oberstown. Have you done that? Because management's as it was. Their recommendations talk about a rupture between senior management and staff. Yeah. Has that rupture been healed, or what's the story there?
Okay, thank you, Deputy.
Yes, I can answer on the specific issue of a review of management. Yes, an independent review of management was undertaken. That was one of the first recommendations. In fact, it was underway at the time and was completed soon into 2017. I think nobody was as aware as we were of the rupture, the challenges between staff and management. These were live issues at the time. This is not, none of the content of this was a surprise to us. We were working tirelessly and have continued to work. I won't labour the point, Chair, but it is something which was, all of these issues were on our table in one form or another. That is not the concern here. And I take your point about being critical. I have deliberately not sought to articulate things in more detail because I do not want to cast any aspersions on the work that was done, but viewed through the constitutional and the perspective of the legal responsibility that the board has, brings you to a different place. That is my view.
Explain just what it's literally like just
to conclude proceedings.
The HICWA report identifies somebody in Oberstown. The HICWA 2018 report, which is under the same constitution, identifies an individual in Oberstown. Now, how the same constitution, the same law?
I think it's fair to say that HICWA has an established methodology which ensures triangulation right across. The inspections take place. There's 5 inspectors at a minimum.
There's no legal impediment. The issue is there's no legal impediment.
Once the appropriate procedures are followed, there is no legal impediment. I agree with you.
Literally 10 seconds.
10 seconds, okay. Just very briefly, fair procedure has been, your defence here. But in layman's terms, the way to have dealt with fair procedure, I believe that your argument in respect of, the findings mitigated against fair procedure. So, in other words, there was an offering, Chair, by the department to Oberstown and the Board of Oberstown to discuss the issue of fair procedures, but that you did not. You're saying that you took up that offering. Mm-hmm. I don't understand your answer to that, because the evidence we heard from the professors today would suggest otherwise, that there was no further qualitative engagement with the professors on the issue of fair procedures, and it's very hard to find what you're saying in that respect to be credible, to be quite frank about it.
Okay. That's your last contribution. Thank you.
No,
do you wish to conclude?
No, I don't need to add anything else. I have explained my response to that issue. A response was sought from the Director on behalf of the management team and the campus as a whole, and that was forwarded then on to the department for the department's determination of the matter.
Okay. Thank you very much. On behalf of the committee, I would like to thank you for your presentation today and for dealing with members' questions in such a comprehensive manner. The meeting of the Joint Committee is now adjourned until 9:30 on the 13th of February, when the committee will hear from HICWA and TUSA in relation to the recruitment and retention of social workers as part of its consideration under the Work Programme 2019. Thank you very much.